morning, everybody. Welcome to the Courtroom Files Live. It is Tuesday, the 6th of January. My name is Michael Groff, sitting in for the illustrious Dan Soul. He'll be back tomorrow, actually tonight, 8 p.m. East, 5 p.m. Pacific for Sidebar. In the meantime, you're stuck like Chuck with me for the next 3 hours. So let's begin our day in Michigan with a well-spun tale of yore, perhaps a song hearkening back to yesteryear. You never know what you're going to get from the great Judge Jeffrey Middleton. Good morning.
I think we can get this thing resolved. It's alleged that at that time, August 4th of 2022, you stole money from, or you stole something from the Walmart store in Three Rivers, and then you went off the grid. They issued the warrant, and they didn't actually serve the warrant until August of 25. You got arrested. I'm not sure what happened. No, they didn't serve the warrant until December of 25. Then you posted bond. It looks like you spent 1 day in jail. You posted $210 of bond. The normal fine for this is $200, and you'd be barred from Walmart. Let's take a look at this. I looked at it early this morning. Do you live in Albion now?
Yes, sir.
Okay.
Yep, got custody of my children, got a place there.
We have long memories around here, at least I do. I'm not sure what's going to happen when I leave. Nobody will remember anything, but we've often get old warrants that get served. How'd you get picked up on this?
I don't even remember anything about
No,
Walmart.
but when you got arrested in December.
Oh, in December?
Keith, would you give him a Kleenex,
Recently?
ask him to take his gum out?
My apologies.
Well, couple,
Well, I was dropping off my children that night.
and where did you get arrested?
Three Rivers.
Are your kids live in Three Rivers?
Yes, sir.
And so on the December 18th, they ran your plate or something and found an old warrant?
Yeah, I had a license plate light hanging.
All right, well, you used to live with a guy that worked in the automotive department, John Gingrich.
Yes, sir.
And Gingrich said he saw you steal a fishing rod. You used a barcode for a cheaper fishing rod instead of barcode for the fishing rod that you had on it. So they watched the video and compared your photo ID, and they issued this warrant for your arrest 4 years ago. If you plead guilty to this charge, I'm going to give you 1 day in jail credit, 1 day. I'm going to use your bond to pay the fine and the restitution, and you can get on about your business. If you don't remember it, you can plead no contest, or if you wish, you can plead not guilty if you deny it or don't believe that you're responsible for it.
Right. I just like to, I'm
what's
sorry. I'd like to get all taken care of today
All right.
and get on.
Do you remember the incident?
Yes, sir.
All right. Did you switch barcodes on a fishing rod?
Yes, Your Honor.
All right. Well, you must have not been in trouble in the last 4 years, because they didn't
No.
pick you up till this actually happened.
Been straightening up. Got a job, got custody of
All
my kids.
right.
got
I'm
my
also
license back.
gonna put you on a plan on your unpaid tickets around here. You got driving without a license and some other zoning stuff. But in this case, anybody threaten you to get you to the plea
No,
to
Your
this?
Honor.
Or what I told you about what I'm gonna do for a sentence? Other than that, did anybody promise you anything to get you to plead to this?
No, Your Honor.
All right, plead guilty. We end up, I complain about this, being Walmart's enforcer for $25. Be easier if we just wrote him a check. We probably spent $500 in resources to deal with this, but nonetheless, I'll show you pled guilty. I'm going to make this come out to $210. There's a $75 crime victims' rights fee, a $50 state minimum fee, $25 restitution to Walmart. That's $150. And a $60 fine that comes out to $210. 1 day jail credit 1 day, and you're barred from Walmart for 1 year. So you owe $0. All right, that resolves this case. I'm going to have the court officer take you out to the court and talk about your unpaid stuff and set up a payment plan
Yes,
to
sir.
get all these old things taken care of. Like I said, this warrant issued in 2022 and you didn't get arrested at 2025, which means you haven't been in any trouble in the last 3 years. But I want you to pay these old tickets. And
I got a little bit of money I can put towards them today too.
all right, very good. You're good to go. Thank
All
you.
right, thank you, Your Honor.
All right.
Morning, everybody. Welcome to the Courtroom Files Live. It is Tuesday. Michael Groff filling in for Dan Soul. Thank you, by the way, Wahoo. Boy, oh boy. All right, Mike, you need another cup of coffee. Thank you, Wahoo, for the $2 super chat. And I say Yahoo to that. All right, back to more Judge Middleton.
Is Kenneth Black here? Patrick Jones? Alicia Slater? Which
Yeah.
case?
Your Honor, did Mr. Moss, does his attorney actually file an appearance?
He has.
Oh, okay. Well, then I'll cross him off my list.
He's from Canton Township, or the defendants. He's from Detroit. He's from Lathrop Village, which is a little 1 square mile thing on 12 mile.
5 blocks from where I grew up.
Rough neighborhood.
Yeah, right.
Is not an upscale northern suburb of Detroit.
Your Honor, I do have a walk-in who's presenting himself today under 762.10D. Mr. Pablo Pena, P-E-N-A.
All right, Laura, somebody, Shayna, Jenny, could I have whatever we've got on Pablo Pena? Well, let's talk about the people that didn't show up. Kenneth T. Black of Kalamazoo previously failed to appear on December 23rd. He's charged with no insurance. He has 2 previous no proof of insurances, one in Kalamazoo and one here, and he didn't pay the fine here. So we're going to issue a bench warrant for him. He does appear to have a valid license. I don't have a phone number. I'd wake him up. I'm going to issue a bench warrant on is $500 cash or surety. $48-hour hold. If anybody knows Kevin T. Black of Warbler Drive, Kalamazoo, needs to get in here. Mr. Upshaw is joining us. Mr. Moss, would you come up to the podium, please? Good morning, sir. Are you Stephanie? Good morning, Mr. Upshaw. Welcome to Centerville.
And good morning to you, and thank you for allowing me to participate on Zoom, Your Honor.
Well, this is just a simple arraignment. We should be able to transact this by Zoom. Are you Justin Trayvon Moss?
Yes, sir.
Mr. Moss, you're charged with assault with intent to commit great bodily harm by strangulation and domestic violence. Allegation is that that happened in Three Rivers on November 10th. The complaining witness is your previous girlfriend, Stephanie Clemens. The first charge, assault, great bodily harm, less than murder with strangulation, is a felony. It's punishable by up to 10 years in prison and a fine of up to $5,000. Second count, domestic violence, is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Bond was set in the amount of $5,000 cash or surety, and you have posted the bond. They directed that you participate with community corrections. Yes. Are you presently wearing an ankle monitor?
No, sir.
Are you on some sort of other monitoring system?
I call once a week and check in.
All right. Well, because this is a felony, I don't have jurisdiction to take your plea here. We have to set it for what's called a pre-exam conference. And we're going to coordinate with your attorney, Mr. Upshaw, to see that that date works.
Your Honor, on behalf of Mr. Moss, Randall Upshaw, P number 43574.
Give me that P number again.
43574.
And you're directing your client at this time, obviously, to enter a plea of not guilty.
That's correct, Your Honor.
Mr. Upshaw, we do our pre-exams on Tuesday mornings, and we do the preliminary examinations on Tuesday afternoon. So the regularly scheduled date for this case would be a pre-exam next Tuesday, January 13th, with a preliminary examination at 1 o'clock on January 20th, if it's needed.
If I may, Your Honor.
Yes, sir.
Your Honor, I've spoke with my client because I have absolutely no discovery and in the dark on this matter. My client is willing to waive his right to have a PC or the preliminary exam within 21 days. I also would like to inform the court that I had a pre-scheduled, because I didn't celebrate the holidays, my wife and I have a pre-scheduled flight out of the country from the 15th through the 20th. I'm asking this honorable court if it would consider allowing my client to waive the 21-day rule and so I can also get discovery and set this beyond the 21 days for another PC.
All right, well, that's problematic. I don't have prosecutor input here. The victim advocate is here and the complainant is here. this often happens. In fact, it happens every time when out of area counsel come in. They've often got conflicts with their other practice. And certainly vacations are hard to come by. The defendant has posted bond. As far as I can tell, he's complied with all terms of his bond. Have there been any allegations of bond violations? All right,
None to my knowledge, Your Honor.
I'm gonna set pre-exam for January 27th. I really don't like this, but at 8:30,
Speak up.
and the prelim, if necessary, for February 3rd. You did file an appearance, certainly, and I'm not sure what's up with the discovery, but we just did the arraignment. You should make contact with the prosecutor's office and get the information. I'm not sure exactly what all there is. Good morning, Mr. Knopfinger.
Morning, Judge.
Have you got something for me this morning?
No, not yet. Tim George.
Do we know what we're gonna do with Mr. Dusha Tellier this afternoon?
We should know by mid-morning, Judge. I've already spoken to Mr. Rivera about it.
All right, thank you.
Really.
All right, Mr. Moss, let's talk about your bond conditions. Do you live in Canton Township?
Yes, sir.
What do you do there? What's your occupation?
I play professional basketball. I travel around the globe, playing for different countries.
All right, and so this is what league are you in?
Basketball. Right now, I have a contract coming up for the Sipa Copa League, which is in Mexico.
Well, you're gonna need to stay here. You can't leave the country, you can't even leave the state yet.
Mhm.
You don't have the court's permission to leave Michigan. You certainly can't leave the country. So delaying this is difficult for you as well.
Your Honor, if I may,
Yes.
if I'm attempting to, I sent some documents about his contract, and I'm attempting to talk with the APA at this time to see what resolutions he and I can make. Can you tell me your court, would you happen to know the APA that will be handling this?
I don't know. The person who authorized it, let's take a look, was probably, we're not that big. We only have 5 prosecutors. Maya would direct you to ask for prosecuting attorney Deborah Davis. The warrant was actually authorized by can't tell. Angelique Camfield. So she's the person that knows about it. She's very capable. She's a longtime career prosecutor from other jurisdictions as well. Angelique Camfield.
And I would just like, I apologize again.
That's the downside of not being here live and in person. You could just walk down the hall and talk to them. But as I said, this is just an arraignment. And so I'm not gonna do anything without input from the prosecutor. So right now he can't even go to Howe, Indiana. He's not allowed to leave the state of Michigan. And where'd you play your undergrad? Miami?
No, I went to Buffalo, New York.
All right. Why are you wearing a Miami shirt?
Oh, well, right now they're on the winning streak. They just beat Ohio State.
Nebraska beat Ohio State last night in basketball. They beat the Spartans and they shouldn't have, but Spartans beat USC by 30 points last night.
Mhm.
All right. Good morning, Mr. Thal.
Morning, Your
Good morning, Mr. Sopanos.
Morning, Your Honor.
All right. So let's review. I keep getting disoriented, so let me stick to the point here. there are bond conditions. Let me find it. As far as I can tell, you've been in compliance with the terms of your bond. Do not have any contact with Stephanie Clemens. Clemens is a Three-Rivers name. I think I knew her grandparents. Did your grandparents live on Michigan Avenue? Yes. Nice people. They're Jehovah's Witnesses and landlords. All right, no contact with Stephanie Clemens. Comply with all directives of the Community Corrections Board. Shall not leave the state of Michigan. No firearms, no assaultive or threatening behavior. Now, the bond could be amended if your lawyer and the prosecutor talk with each other and agree to some conditions. When would your contract start with the Mexican League?
I was hoping for, well, they're hoping for me to be there by January 15th.
Well, it ain't gonna happen unless something else happens.
Yeah, I've updated them on the situation.
For now, your next court date is January 27th at 8:30. I want you to comply with the conditions of your bond. Mr. Upshaw, my recommendation would be you contact the prosecutor's office and ask to speak to Angelique Camfield. She's the person that authorized this. She has charging authority and plea authority. Let's assume that the matter is resolved with some sort of a negotiated plea, even to a domestic assault. As you know, there's a deferral statute that could apply to this, but I don't know enough about it. Reading the affidavit, this is bad. It's scary and dangerous. And so I don't know where this case is headed. Mr. Moss, I'm going to have the bailiff take you out to the court office, and they're going to give you a notice for your next court date, which is January 27th at 8:30. And if needed, the next date after that would be February the 3rd. If there's some change in this, we'll discuss it. But this isn't a traffic ticket. This is a serious 10-year assault with intent to commit great bodily harm felony charge. So it isn't going to go away with a swipe of a hand. This is some serious stuff. So you go out to the counter, stay in contact with your lawyer, Mr. Upshaw. He'll get the police report. I don't know if there's 911 tapes or photographs or videos or whatever evidence that is. He'll get a copy of it. Stay in contact with the conditions that you've got from community corrections. All right, you're good to go, sir.
Thank you, Your Honor.
Thank you, Your Honor, and have a good day.
Barbara, thank you so much for the $5 super chat. And of course, for the kitties. Well, for the cat here, Freya, she is lurking about somewhere, I believe sleeping right now, but you never know when she'll join us in the studio. That's something I share in common with Dan. He has Ellie, I have Freya, and sometimes they like to appear on camera. Sometimes they like to say hello to everybody. You never know. That's cats for you. That's the chaos beasts. All right. So Judge Middleton, we hung with him a little longer this morning, and the reason we did that is because, for those of you unaware, it is Judge Middleton's final year on the bench. He is termed out after this year in Michigan. And so we tease him a little bit. We like to razz a little bit about talking about tales of selling a bridge or memories from Woodstock or whatever. But it's all in good fun. And besides, that guy should write a book when he's done. All right, meanwhile, we'll do what so many of you like to do in the month of January. Let's head to Florida. Are we going to head to Florida? Go down there, see what's going on with Judge Mercer. Oh, I love Judge Mercer. First appearances.
You have a warrant out of Clay County, Georgia, I know that you've had a chance to talk to Mr. McDaniel about the waiver of extradition process. I do not know if you've had a chance to talk to Mr. Green about that process. So Mr. Green, let me just see Mr. McDaniel, tell me where he stands and we'll see what Mr. Green's thoughts are. Mr. McDaniel?
He was going to sign the waiver, so I'm not sure what.
I'll talk to Mr. Green first.
Okay. So Mr. Green, he says he would like to talk to you before signing that waiver. Is that right, Mr. Peeler?
And I can sign it, whatever you recommend.
So Mr. Green, what do you want him to do? Or what do you recommend he does as far, do you have a recommendation for him?
Judge, I guess.
I think you always could, but they didn't. So back years ago, states chose not to extradite on misdemeanors, and now, like our county and apparently this county in Georgia will put a radius limit on it. We'll go get you out of state, but only we'll go X number of miles. For instance, Jackson County will not go to North Alabama and get somebody on a misdemeanor, but we'll go within a couple hundred miles. So I think, somebody's talking there at jail. I couldn't hear who that was. I don't know. But so ours are the same way. I think ours is set at 2 or 250. This warrant, Mr. Green, says that particular county will pick you up within 150 miles. And they have notified our sheriff's department that they'll come get him from here. That's all I know about it.
And Mr. Green,
if you want time to research it, Mr. Green, just a second, Mr. McDaniel. If you want time to research that, Mr. Green, that's perfectly okay. He's just not going anywhere because he's got a warrant from another state. Mr. McDaniel, we're trying to say something?
Yeah, Mr. Green, I guess in the past, they have not extradited him. I'm not saying they won't, but I suspect if he signs this waiver, they're going to call today and find out. So you're going to have to do your research. They either are or they are not. You know what I mean? And if he doesn't sign it, I mean, we're going to sit here until we do call him. I mean, someone's got to call him. Jail's going to call him today. And if they don't want to come get him, they're going to let him go. I'm not positive they're going to come get him because in the past they did not come get him. So I'm not positive they're going to come get him this time.
I have no authority to set a bond on an out-of-state warrant. Under Florida law, they have 30 days to pick him up, but he will know today if they're coming to get him or not, and that I review the cases at 15 days. This county, Fort Gaines, which is probably an hour and a half from here, usually they're going to have him back in that county within a week. If it follows their normal course, they're just slightly above. Fort Gaines is across the river from Eufaula, so it's pretty close to us. Okay, but he's got to sign the waiver in the presence of a judge. So do you want him to go ahead and sign the waiver so that clock starts ticking? Because they have that time limit doesn't begin until he signs that waiver in the presence of a judge.
How long do they have?
By law, they have 30 days, but they've never taken that long. In fact, 15 days is just a catch to kind of make sure things are on track. I've never even seen one at 15 days from this county. It's almost as good as Dothan. Dothan's going to pick them up within 2 or 3 days normally. Right. Mr. Peeler, are you okay with that?
Yes.
All right, so there's a waiver of extradition there. If you want to go ahead and sign it, then I'm going to ask the jail to notify them today that Mr. Peeler has signed the waiver, Corporal, and let Mr. Peeler know their response, please. Mr. Peeler, if they follow their normal practice, and I can't tell you a specific time, I can just tell you their normal practice with that county and that part of Georgia is probably 2 or 3 days. But I obviously can't promise you that. Under Florida law, they have 30 days. I don't ever let it get to that point without reviewing the case. So if you're still here in 15 days, I'll see you. That's highly unlikely. In all likelihood, Mr. Peeler, they're going to either say we're not coming to get him, which would contradict what they said yesterday, or they're going to come get you within a couple of days, and you can deal with this once you get up there. The other thing that may happen, I know Mr. Green, I don't think you're licensed in Georgia. Mr. Green may have a contact in Georgia that might get them to set a bond up there. If the judge up there sets a bond, then you can post it and be released.
Yes.
But right now, the clock has started ticking on them today. Mr. Peeler, do you have any questions?
No.
Mr. Green, anything else? Yes, sir. I don't think Georgia's not like Alabama. In Alabama, they have to be physically present in the state to post bond. I'm pretty sure Georgia, if they set him a bond, he can post it here without going up there. Okay. All right. Thank you. Wish you the best, Mr. Peeler. Thanks, sir. Next case we have friends or family here for Mr. McDaniel is Mr. Cook, John Cook. John. Mr. Cook, good morning. You're here on the page up here, Mr. Cook, for no motor vehicle registration where you signed a notice to be back in court and then didn't show up. Mr. Cook, you have some relatives in the courtroom on your behalf. Mr. Cook, I believe that your family, I'm not sure the relationship, your mother has produced a registration for Mr. Mitchell this morning. So I think Mr. Mitchell may have an announcement in your case.
Yes, Your Honor. The valid motor vehicle registration has been provided to the state. So at this time, the state will announce a no information on the record and a no information has been filed in this case.
It's already been filed?
Yes, I went ahead and filed it.
So Mr. Cook, Mr. Mitchell's dismissing the case against you based upon that registration. He didn't get it until today. But you need to understand if you get a notice for court date, you don't have the option of just, you got to make sure you're here when that notice is for, and you've had a handwritten notice for yesterday.
Yeah.
And that's why you spent the night in jail, because you didn't show up in court. But the case against you has been dismissed. Mr. Cook, do you have any questions?
Yes, sir.
Family have any questions? So he'll be processed out. Usually that's a 30-minute process. Y'all can pick him up at the jail. Mr. Cook, hang on just a second. Mr. Cook, I think you have a civil infraction, but it wasn't the same day and time. So you need to understand, if you don't take care of that civil infraction and your time's running out on that, then your license is going to be suspended. I'm just making sure you're aware of that, Mr. Cook. You understand? You know what I'm talking about, right?
I don't.
You got another ticket after this one. You got a ticket for what, Mr. Mitchell?
It is failure
Like
to
failure
have,
to use due care or something like that?
failure to have vehicle under control.
You got a citation for failure to have vehicle under control that you've not paid. Does that sound familiar to you?
All right, yes, sir.
Okay, if you don't pay that, your license is going to be suspended. And your time is running out on that. You received that in early December, and you have 30 days to pay it, so your time's running out. So family, you understand, he obviously didn't even remember it, which is very concerning. He forgets his court date, now he doesn't remember a ticket he got. So, there may be some other issues y'all got to deal with, okay? Wish you the best, Mr. Cook.
Yes, sir.
That's it for people in the courtroom, friends or family. Mr. McDaniels, we can go back to the top of our docket, which is Diego Alejandro Garza. Mr. Garza, good morning. Mr. Garza, you're here because you've been accused of one count of aggravated battery. Mr. Garza, there is probable cause in the complaint. But I've read your criminal history this morning, sir, and it appears to show no prior criminal history. Mr. Garza, that means, according to what I've been provided, you've never been arrested or charged with a crime anywhere. Is that accurate?
Yes, sir. I've never.
Perfect, Mr. Garza. So let me see what additional information the attorneys have. Then I'm going to address your bond or your release status. Mr. McDaniel. I don't have anything, Your Honor. Mr. Mitchell.
Nothing at this time, Your Honor.
So, Mr. Garza, when I read the complaint, I think it's aggravated battery because of the severity of the injuries. Apparently, there are some spinal cord or some maybe not spinal cord, some spinal column injuries, some what do you call it?
Contusions?
Vertebrae, broken vertebrae. I don't know the results of it. The complaint doesn't give us a lot more information. There are two witnesses that basically say you were acting in self-defense, but at least one of them contradict your version. So this kind of all plays into the signing of the warrant. Your version is you struck the person one time. I think your own relative says that's not accurate. You struck the person multiple times. So there's some nuances there. Of course, his version, the alleged victim's version, is he was struck from behind. None of the other witnesses say that. So, Mr. Garza, your no criminal history really helps you. Let me ask you a couple of questions, though. How old are you?
I'm 21.
Okay. And are you a student, or are you employed, or neither?
Neither.
How do you live? If you're 21 years old, you don't have a job, you don't go to school, what do you do all day?
I help around the house I live with my mom and my stepdad, and I am in the process of looking for a job.
Is there any reason you don't have a job? Is there any kind of disability that prevents you from working?
No, sir. I've been we haven't really had a car for a good bit, so I haven't been able to go back and forth from jobs.
Okay. All right, so Mr. McDaniel, Mr. Mitchell, what I think I'm gonna do in this case is based on his criminal history, his lack of employment, I'm going to set him a misdemeanor bond or the equivalent of a misdemeanor bond based upon, it appears there may be some defenses to this charge. I'm not sure, obviously, I have very limited information, but there are serious injuries. So Mr. Garza, I'm going to set you a $2,500 cash or surety bond based upon the allegations against you. You do have a condition of no contact with alleged victim. Mr. McDaniel, is there a request for a cash bond in this case, or you prefer the cash or surety option?
Cash bond, Your Honor.
Mr. Mitchell, any objection?
No objection to
Okay.
it.
So what that means, Mr. Garza, is you can post a $250 cash bond. You don't have to go through a bondsman. Your bond is $250 cash. When that cash bond is posted, you'll be released. You don't live in the same home with the alleged victim, correct?
They did.
We did at a time, but he moved out.
Okay, so he's been gone as of when? Yesterday or weeks ago or what?
Weeks ago.
Okay, so you can go to that home, just have no contact with him. Mr. Garza, you'll get to use the phone in a few minutes, sir, to try to post that bond. I'm also going to ask the jail to give you a notice for your court date. Your court date in circuit court will be February the
3rd, I think. Yep.
February 3rd at 8:30. Mr. Garza, do you have any questions?
What was the last thing you said?
February 3rd.
Before that.
February 3rd at 8:30. They will give you a notice for that day.
That's all, Your Honor.
Got it.
All right. Wish you the best, sir.
Thank you so much.
Yes, sir. Andrika Barnes. Ms. Barnes, good morning. Ms. Barnes, you're here because you've been accused of one count of robbery by sudden snatching. Ms. Barnes, I've read the criminal history. There is probable cause for the charge, ma'am. There's also, I've had a chance to look at your criminal history, so I'm aware of your multiple prior arrests that you have. So, Ms. Barnes, I think you're entitled to a bond. As far as I can tell so far, let me see if the attorneys have anything to add before I set that bond. Mr. McDaniel.
Your Honor, I'm not familiar with the past history. I did read the complaint, so you just asked the court maybe for a cash bond,
Okay, Mr. Mitchell.
If she's wanting to pay a cash bond, we have no objection to that.
Ms. Barnes, I'm going to do the same thing I did with the last gentleman. I'm going to set you a $250 cash bond. You have a condition of no contact with the alleged victim, which I believe is your mother. Is that right, Ms. Barnes?
Yes.
Okay, so what that means is if you post the bond or when you post the bond, you can have no contact with her. You can't go to her home. You can't live in that home. You can have no contact with her. If she wants to have contact, we'll cross that bridge if that happens. But she's not here today asking for contact, so I have to assume she does not want contact. She may, I don't know. But if she does, we'll cross that bridge. But you can have no contact with her until a judge authorizes it first. But in the meantime, you've got the right to post a bond. You call anybody you want to try to post a bond, except her. You cannot contact her about posting the bond. Ms. Barnes, do you have any questions?
Like all of my stuff is there. My purse is there. Everything is there.
Okay, so
I mean,
you can get that stuff. There's a way to get that stuff. Mr. McDaniel would talk to you about that, but you cannot contact her. And we need to give a notice to appear to Ms. Barnes for February 3rd at 8:30. Ms. Barnes, do you have any questions? I haven't heard anything. The last case on the first appearance docket is Jeremy Booth. Mr. Booth, good morning. Mr. Booth, you're here for first appearance because you've been accused of one count of driving under the influence and one count of refusal to submit to a breathalyzer exam. Mr. Booth, there is probable cause for the offenses. Mr. Booth, I'm going to appoint the public defender's office to represent you for first appearance purposes. Listen to Mr. McDaniel, and he's going to tell me where we're going this morning. Mr. McDaniel.
Your Honor, I spoke to Mr. Booth. At this point in time, we're going to plead no contest to the charges as listed. You understand, and he'll be sentenced to 4 months in the county jail. Both of them run concurrent. The refusal may be a 60-day sentence, but it'll run concurrent with the 4-month sentence. $1,078 in fines. He signed his plea waiver form, waiving his right to jury trial and call witnesses, and that'll resolve this case today.
Thank you. Mr. Booth, the uncertainty with the refusal is because that's a relatively new crime. For years, refusing to submit to a breathalyzer was not a criminal charge unless you had a prior refusal. That changed, I believe, July 1st of 2025. So our uncertainty is it a first degree misdemeanor or a second degree misdemeanor? We've had 1 or 2 of these cases since then, but not many. Let's look it up and see what degree crime it is, Mr. Booth, and we can probably, well, the officer didn't put the statute number on there. Wow. Yeah, here it is. Here it is. He put on, it's on the other page. 3/16/1939. Mr. Mitchell, do you know?
I think it is a second degree misdemeanor for first time refusal.
How confident are you of that?
What's that statute again?
I'm 95% confident of that also, but
1939.
Let's see. Refusal to submit to a lawful test of his breath or urine is a misdemeanor of the first degree. It is a first degree misdemeanor. Hang on. Yeah, it's a first degree misdemeanor. So if you enter this plea, you're going to be sentenced to 4 months in jail on each case, but they're running concurrent. That means they're running at the same time. So it's 1 4-month sentence, essentially, with credit for the time you serve. Mr. Mitchell, is that agreeable with the state?
That is agreeable with the state, Your Honor.
Mr. Booth, any questions about that agreement, sir?
No, sir.
Mr. Booth, is that the plea you would like to enter, sir?
Yes, sir.
All right, Mr. Booth, I'm going to accept your plea of no contest to those 2 charges, driving under the influence. That's as a second offense. Refusal to submit to a breathalyzer. First offense, the judge is guilty of both those offenses, sentence you to 4 months in jail on each case concurrent with each other. $1,078 court costs and fines, credit for 1 day that you've already served. Mr. Booth, you certainly may participate in the Public Works Trustee Program. I hope you do. That'll help you get quite a bit of gain time off of this sentence. If that interests you, just talk to the jail staff about that after first appearance. Mr. Booth, do you have any questions about your sentence?
No, sir.
Wish you the best, Mr. Booth.
Your Honor, I did want to point out in subsection E, it does say first time is a second degree misdemeanor. So
I'm pretty sure
we may have to clean that up.
Okay, hang on just a second then. So in subsection D, it says, hang on just a second, Mr. Mitchell. In subsection D, above that, it does say second degree. Where did I see first? Oh, it says subsection D, it says first, but that's if they have a prior refusal. So if there's no prior refusal,
Second degree.
it's a second degree.
Yes.
It's a second degree for a first refusal or a misdemeanor of the first. Wow, that's a mouthful there. Okay, so what it says is, who, after having been so informed, refused to submit to any such test when requested to do so by a law enforcement officer or correctional officer, commits a misdemeanor of the second degree for a first refusal or a misdemeanor of the first degree for a second or subsequent refusal. Okay, so it's actually a second degree misdemeanor. So we need the disposition to reflect. Thank you, Mr. Mitchell. That it's 60-day jail. Excuse me. It's 60-day jail sentence on the second degree misdemeanor first offense refusal. That's the maximum he can receive on that charge. The other charge will be the 4-month jail. So they still run concurrent. So we're going to correct that on the disposition, Mr. McDaniel. Thank you, Mr. Mitchell. Mr. McDaniel, is everything I had on my first appearance list. Anything else from the jail this morning from the public defender's office?
No, Your Honor.
Well, it appears that that's going to wrap it up for Judge Mercer, first appearances. And yes, they're dealing with new laws down in Florida. Now, that one went into effect last July. The refusal to consent to a breath test, that's a whole other topic for sidebar. But speaking of, we'll be talking about brand new laws that are just coming on the books this year, because here in the U.S., we obviously don't have nearly enough laws. And so that'll be a hot topic for us tonight, 8 p.m. East, 5 p.m. Pacific on sidebar. Hope you do tune in and check us out over there. All right, in the meantime, we're going to head to Texas. We haven't checked in yet, at least I haven't, in my guest hosting duties with Judge West in a hot minute. So let's see what's going on in
I'll take a look at that
Jefferson
after
County
today.
with Judge
Let's
West.
see where we are today. All right, are you Michaela Collier? And so this is 24 DCCR 0751. Ms. Collier is on probation for the second-degree felony offense of aggravated assault with a deadly weapon. That probation was from October 7th of 2024. And we did a 10-year term in prison that was probated for 10 years, which we have now, I think, figured out, and I don't disagree with Mr. Kimmler that this should have been a deferred probation instead of a straight probation. I'm going to do a little research on that, though, after today and figure out exactly, you filed a motion to quash. I'll take a look at that and figure out what our options are as far as that issue. What we're here for today, I mean, regardless of all of that, Ms. Collier accepted responsibility, pled guilty to the offense, whether it was a straight or deferred, took a probation. The motion alleges that she's violated her probation by committing a new offense of assault causing bodily injury October 17th of 2024, not mailing in or reporting online for several months, not reporting address change, and just a little bit behind in court assessed fees. And Mr. Kimmler has asked that a bond be set. Currently, there's no bond in this case. I think she's obviously entitled to one based on the nature of what's going on. Mr. Nichols, what's the state's position?
I just asked that the bond be sufficient to secure her appearance in court, Your Honor.
What's the status of that?
I believe it's a pending misdemeanor assault.
It's out of county.
Is it?
It says Jefferson County.
Is it? Okay.
Yeah.
Did that happen in Jefferson County? UK? Okay, yes, it's just.
So that's still pending?
I looked at it yesterday, Judge. I think it is still pending, unless I'm mixing up with another summer case.
So, Ms. Collier, I'm just going to ask you a few questions so I know some information before I do this. Best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right. So, Ms. Collier, where, if released, will you be living?
2230 Suite, apartment 8. My boyfriend bought me an apartment because I was coming here and myself in.
Speak up.
My boyfriend had bought me an apartment because I was coming.
Hold on a second. Y'all, I'm having a hard time hearing if today for some reason, and the voices are low, so.
Speak up.
Swigum, apartment A?
Yes, apartment
Okay.
8.
8, gotcha, okay. And who else will be living at that apartment?
Jamal Guidry, my boyfriend. He bought the apartment just so that I could come move back.
And is Mr. Guidry in any kind of trouble?
No, ma'am. He's clean, no criminal record, no none of that. He's a working man. He comes from.
Is that in Port Arthur or Beaumont?
It's in Beaumont. It's Mosaic Apartments.
Okay. So where were you living?
2010 East 7th Street, my mom's house, where I had reported to my probation officer in South Dakota.
Oh, in South Dakota?
Yes, ma'am.
Okay, all right.
I think she had permission to be there.
Yeah.
Yeah. She was reporting here online. That's why I knew she was somewhere else.
And I had a.
And good morning, probation's here as well. It looks like other than failing to report online for the beginning of this year, or last year, we're 2026, 2025. And the address issue, other than that new offense, things were going okay where she was in South Dakota?
No, ma'am. She, South Dakota actually rejected her case because she was not on the list of the original address, which was your mom's. Right, so they rejected her case. She had to come back. She came back, but then she went back without permission. That was the
problem. Okay. So here's what I'm going to do, Ms. Collier. I'm going to grant Mr. Kimler's motion to set a bond in your case. I'm going to set the bond in your case. Well, let me get a little more information so I can make sure I have all this right. Who is the complaining witness in the 2024 misdemeanor case?
It's a acquaintance, Judge. I don't think it was a family member or somebody she'd gotten an altercation with, actually drove over with her car. Was the original offense.
What's the name of that person? Do we know?
I have it right here. Daisy Anna Brown.
Say it again.
Daisy Anna Brown.
See. All right, so here's what I'm gonna do. I'm not going to make the bond real high because I am also going to require that you get a GPS monitoring device, and so that obviously we'll know where you are with some other conditions. And so I'm going to set the bond in your case at $10,000, okay? I'm going to order as a condition of that bond, if you make it, that you remain in Jefferson County, Texas. You cannot leave Jefferson County, Texas. Hold on, just listen, okay? You will be required to wear a GPS monitoring device. You will be reporting in person here in Jefferson County. There's no leaving the county. If you leave the county, you're back in jail and we're on a whole different path. Do you understand? You will live at 2730 Sweet Gum, apartment 8 in Beaumont, unless you give notice to probation and they let me know and I approve somewhere else for you to live. So you can't just move and then tell us. You need to let them know, and then they'll let me know or let Mr. Kimler know. I want to know where you're going, who you're with, and those kinds of things. On probation, you cannot be around anybody else that's on probation or charged with an offense. And so you need to get a job, go to work, go to probation, go home.
Yes, ma'am.
That's it. Do you understand?
Yes, ma'am.
And then I will set the case for just another, maybe no more than a normal reset. And we'll take a look at what our options are on getting the issue worked out, if possible, with regard to the type of probation. And so, Mr. Nichols, if you'll do some research into that as well, see what our options are, and I'll get Mr. Florence to take a look at it as well. All right? You can go back with the bailiff.
Thank you.
Would you also run and go let her know, part of that bond condition is that she has no contact with Daisy Ann Brown?
Yes, sir.
Before they take her back? I didn't say it, but I'm making it to order. Thank you. Wayne Cummings.
This is just, we're asking for a bond also.
You're whispering again.
I'm sorry, we're asking for a bond on this.
Yeah, that's what we're here for. Are you Wayne Cummings? Mr. Cummings, the best you can, raise your right hand, please, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. And so this is cause number 18-29640. Mr. Cummings is on probation for the offense of manslaughter A motion to revoke community supervision has been filed, and Mr. Kimler's filed a motion asking that I set a bond. Looks like the date of the probation was from October 22nd of 2018. A 10-year term in prison, probated for 10 years. New offense alleged in that motion is a driving while intoxicated, October 5th of 2025 in Orange, at a location other than his residence at 4:15 a.m. on October 5th in Orange, and that he was intoxicated on that date and behind in court-assessed fees. Mr. Kimler, you may proceed.
Your Honor, first observation is Mr. Cummings did turn himself in. This wasn't one where he headed for the tall grass when he found out he had an MTRP. He did turn himself in. I understand, I think this is straight probation. It's not entitled to a bond. However, with the Orange, and of course, Mr. Smith is familiar with Orange County. It may be a while before that DWI is filed, so I don't know how long it's going to take for the state to be in a position to try to prove that up. So we're just asking for a bond pending this position if they're going to proceed on the DWI. Obviously, they could proceed on the administrative violations.
Mr. Smith?
My concern, Judge, is firstly, the manslaughter was basically a DWI where he hit somebody and killed them. He had issues. Safety was a recommendation for the original probation to go through in the PSI. This new offense, the allegations apparently show he was out at 4 in the morning and was intoxicated driving. And so I would have reservations and concerns. I think there's been a relapse, and he's not actually entitled to a bond. It's a straight probation versus a deferred. So we would be opposed to a bond.
Do you know the status of the Orange County case?
I don't, Judge.
I don't think it's been filed yet, 100%. I checked before.
If it was just knowing how they work over there, if it was just alcohol, they would have already probably had the results.
Y'all are just guessing. Is there a way for us to find out? Is there any kind of hold on him?
If you want to hold it for a minute, I can call the DA's office.
Yeah, let's do real quick, and we'll just do it real quick. Just have a seat, sir. And there's not, I'd like to know with it. Is there Mr. Bynum? Mr. Cashin? Oh, I don't think he's. Mr. Cashin's going to zoom in, and he hasn't zoomed in yet, so I'm going to hold Mr. Williams' case for just a minute.
Your Honor, I know he intends to zoom in. I talked to his son yesterday, but by a note, his brother died on December 1st, and then on December 2nd, he had surgery, had emergency surgery.
Right, he contacted us and said he's going to Zoom. So let me just hold it till he does. Thank you.
All right. While she attempts to get the next contestant to come on down, it's the Courtroom Files Live. We are here on a Tuesday. I am Michael Groff. I am sitting in for Dan Soul. If you thought I was Dan, well, I suggest your eyes might just be as bad as mine. Or maybe we've all just sort of melded into one. Join us tonight, 8 p.m. East, 5 p.m. Pacific for Sidebar. Should be an exciting time there. Of course, tonight's topic, brand new laws that are coming on the books as of January 1st of this year. There's a lot of them, and so we'll be discussing that. If you want to hang out in the chat with us, of course, we highly encourage that. We love to see new faces, old faces, all faces in the chat. And you want to become a channel member, of course. That's always great, too, because you get the pre-show and so much other exclusive content just for being a member here at TCF. All right, we're heading up to Michigan, and it's our first dive into Judge McNally for the year. Judge Dad, good morning, Judge.
Are you Earl Ware?
Oh, before we do that,
Earl
we have
Ware?
to do this. There you
He's
go.
on Zoom, Judge.
Oh, okay. Mr. Ware, your name? You have to unmute, sir.
Hello?
Your
Earl
name?
Ware? Earl Ware?
All right, Junior, right?
Yes.
I'm not sure why he's here today.
He needs time to pay.
How much do you have today, sir?
Shit, I really don't have nothing today. I can have around $50 to $100 in a couple days.
Where do you work at?
I drive trucks, but it's been slow for the holidays.
Can you pay 50 per week?
Yeah.
You pay
Do you
50
need-
per, listen,
Yes.
you pay 50 per week starting Friday. Can you do that, January the 9th?
Can you get it starting Monday?
The 12th, okay?
Is
50
that
a
fine?
week starting the 12th. If you need more time, call the court. We'll go on Zoom again. I'll be glad to give you an extension. You did the right thing, okay?
Okay, and how do I pay? Do I call the court?
You can go on 33court.com with your case number. 33court.com with your case number. And
3-3, like 2 3s or 3 3s?
just 2 3s. 33court.com. 33court.com.
3-3 court. All right, thank you, Judge.
All right, have a good day. Happy New Year.
Same to you.
He's not giving you quantities of the numbers.
Lynette
He's just
Marie
telling
Johnson.
you the numbers.
Who's Lynette Marie Johnson? 25B82374. Is she out there somewhere, Lisa?
No, she's not on Zoom.
Oh, this isn't scheduled. I'm sorry. This isn't scheduled till 10:45. My mistake. White, Antwain White. Antwain White, 25M600877. Antwain White, state your name, please. Antwain White. You have to start your video and unmute and state your name. Name?
Name's Antoine White.
All right. You have a hat on, sir?
Yes, sir.
You're gonna need to take that off, okay? You're charged with commercial motor vehicle, expired or improper plate, and you have the right to a lawyer. If you want one, I will give you one. Would you like a lawyer?
No, sir.
Okay, I gotta see you, sir. You're walking around. You
Walking
gotta
through.
stay in one place, and I gotta have you stay there, or else I'm gonna have to have you come in, okay?
Like I said, I'm on my way to the truck now.
Why am I having you walk around, though? Why aren't you just standing there?
I just said I'm on my way to the truck to sit down.
You're charged with commercial motor vehicle, expired plate or no plate, and that is a misdemeanor, and you have the right to an attorney. I will be happy to give you an attorney if you would like one. Would you like a lawyer?
No.
I can't hear you.
No.
Okay, so you're gonna waive your right to a lawyer. Here's what I'm gonna do. I'm going to arraign you.
Hello?
I'm going to arraign you, and then we'll send you to the city attorney or the prosecutor. You're charged with having a commercial plate violation while you were operating a motor vehicle on I-75 near Dix in Brownstown, December 12 to 75 at 7:10 PM. That is a misdemeanor punishable by up to 500 fines, 93 days jail. Costs are all those. Do you understand that?
Mm-hmm.
I can't hear you, sir. You got
Yes,
out,
sir.
you gotta speak. You can't argue. You can't simply say, or Do you understand what I said?
Yes, sir.
You're presumed innocent. They have to prove you guilty beyond a reasonable doubt. Do you want a lawyer?
No, sir.
I sorry, no, sir, or yes, sir? I didn't hear you at all that time. You got to talk to me, sir. Do you want a lawyer or not want a lawyer?
No, sir. Do not need a lawyer.
Okay, you sound better that time. All right. Now, this allegedly occurred December 12 of 25. Those are the possible penalties, up to 500 fines, 93 days jail. Costs are all those. You're presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent, right to a trial by court or jury, right to question their witnesses, right to bring in your own, right to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights. And we're not going to have a trial of any kind. You understand that?
Yes, sir.
You still wish to waive your right to a lawyer?
Yes, sir.
I'm going to enter a not guilty plea. I'm going to give you a $100 personal bond. You don't have to post any money. Here are your bond conditions. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. I will go ahead and I will set this. You stay right where you're at. We're going to put you got to be patient. We're going to put you in a breakout room with the prosecutor. You'll see if you can resolve it. Either way, you're coming back in front of me, okay? So you'll talk to the prosecutor. Just be patient. They've got others. And then either way, you'll come back in front of me after you talk to the prosecutor, okay? Any
All right.
questions?
No.
All right, good. You're sounding good. I don't know what happened, but sounds a lot better. Thank you. Phillips, Brittany Marie Phillips, 25B149906. Is Officer McParland here? Wait a minute, one second, ma'am. Yeah, you could come on up. Is Officer McParland here?
Not on Zoom.
Brittany Marie Phillips, 25B149906. All right. Good morning, ma'am. Oh, I see. You met with the department rep. Your name?
Brittany Phillips.
You're going to plead to impeding traffic. It says minor damage, no injuries. Is that what you want to do?
Yes,
All right. To the charge of impeding traffic, you plead responsible or not responsible?
responsible.
All right. Please accepted. 195. Original charge of failure to stop assured clear distance dismissed. You go right down the hall and take care of that. You're all set. Thank you. Warnick, William John Warnick.
Yes, sir.
2523455173.
Good morning, Colonel.
Good morning to you. Your name?
William White.
All right. You're charged with operating while texting. You got to be careful doing that. You're going to plead to impeding, right?
Yes, sir.
Right.
Well, in my defense, I was just handing the phone to my wife.
The officer said here he was watching you use your cell phone while the cars were lined up behind you.
I understand what he said, but that was not the case, sir.
Okay, you still want to plead to this?
Oh, I'll take the impeding traffic.
To that charge of impeding traffic, you plead responsible or not responsible?
Responsible, sir.
All right, I'm going to accept the plea 205, original charge dismissed, and you're all set.
Appreciate you, sir.
Have a good day. Thank you. Kenneth James McKay Jr., 25B149883.
There was no charge on that ticket. The impeding traffic.
What do you mean, no charge?
There's a money's fine on that?
205.
Okay, thank you.
Yeah, no problem.
Thank you.
Your name?
Kenneth James.
Okay, so you want to contest the violation?
Yes, Your Honor.
Okay, we'll set it for an informal hearing.
You just said.
And when are we going to do that, Lisa?
January 15th at 9.
I'm sorry.
January 15th at 9.
Okay, so January 15th, sir, at 9 a.m. will be your court date, okay? So you can go down the hall and get your notice. You don't want to take impeding, right? Okay, good enough. You're all set. Thank you. Go down the hall and they'll give you your notice. Thanks. Is Lynette Marie Johnson here? This is good. Okay. You have anything else down there? Mr. Granata, do you have one ready?
I have one in custody, Your Honor, in Trenton Police Department, and I do have one walk-in arraignment.
Okay. Michael Joseph Catanzaro, the third, 25 T6 47293.
Morning.
Good morning to you. Your name, sir?
Michael Joseph Catanzaro, third.
Yeah. So you are going to plead to impeding traffic. They are going to dismiss the stop sign. True?
Yes, sir.
All right, to that charge of impeding traffic, responsible or not responsible?
Responsible.
Plea is accepted, stop signs dismissed. 150 is your total. The hall to your to the cashier. Happy New Year to you, Rachel.
Lots of traffic violations in Judge McNally's court this morning, and some interesting issues with Zoom, of course. Why not? It's the Courtroom Files Live. It's Tuesday, the 6th of January. Good morning, everybody. So good to have you here. And let's take a jaunt, if you will, down to... Let's go back to Louisiana, or let's go to Louisiana for the first time for me in the new year. Say hello to the Louisiana Board of Pardons and Paroles. Good morning.
The date is the 6th day of January. We're in Baton Rouge at Department of Correction headquarters. To my right is Jerry Ledoux. To my left is Chuck Tillis. My name is Steve Prater. We're talking to you, Mr. Brandon Broussard at Lafayette Parish Correctional Center. Is that correct?
That is correct. Yes, sir.
Is there any staff in there with you? Would
Yes,
you
sir.
introduce yourself?
Joseph?
Corporal, thank you for hosting us today. We appreciate that. Mr. Broussard, would you tell us what your DOC number is?
Good morning to you all. My DOC number is 447 143. 447 143.
Yes, sir. That's what I have down here. And do you have a waiver form in front of you?
Yes, sir, I do.
And did you sign that? And we're ready to proceed with this hearing.
Yes, sir.
Okay. Well, my name, as I said before, is Steve Prater, and I'll be conducting the interview with you this morning. And we've got 3 people that want to speak on your behalf. And I'm going to go over the only rule violation that you're accused of violating, or condition of your parole, was the fact that you were arrested for a domestic abuse battery on September the 28th of 2025. And that's condition number 4, which says that you'll stay away from any kind of criminal conduct. And so that's what we're here to discuss this morning. How would you plead on that? Are you guilty of that domestic violence?
I would plead guilty. I never been in the rain. I never been to court on it at all. But yes, I did what I did. What occurred on the video. Yes, sir. I mean,
hard to deny that, huh?
Yeah, it's hard to. I'm not sure. I wouldn't deny it at all. I mean, I did it. It's not something that I'm proud of. I should have called the cops first before. When I was scratched up and I got evidence and stuff showing from what happened to me first, I should have went immediately called the cops right then and there instead of waiting. But
okay. All right. And why, since I'm handling this case, we'll go ahead and talk about it right now. You've been in jail for 6 months, or I say 6 months, 3, 4, 5 months, 4 months. Yes, on this charge. And why were you getting her out of the car? We've all seen the video.
Okay. This is what occurred. As I was packing my stuff and putting it from her house into my car, that's my car she's in. She came with her car and blocked the back of my car off with the Honda Pilot that you see. If you look into the road, there's some stuff in the road. She started taking the stuff out of my trunk and putting it in the street. I went to the street to get the stuff from and put it back, and she got in my car right then and there. And then she started acting like she wanted to burn and do things. And I tried to go in there like, hey, stop, don't do that. Those are my things. And she took off a little bit and tried to move around and stuff. And I was finally able, after a little period of time, after getting scratched, because I was trying to get the lighter out of her hand. And as I was getting the lighter out of her hand, she clawed me on my neck and my arm and my head area. And I have pictures of those. And after that, the car was parked, and I finally got her phone from her. That's what made her finally decide to get out of the car, because I had her phone, and I was like, look, come in, let's talk about this. Let's stop doing all this stuff, you know. And as she was in the car and I was trying to pull her out from the seat, because she was holding on to the bottom of the seat with her hands, and I pulled her from the rear, and as I pulled, she let go. I immediately looked like boom. And then she got up and I got up, and we were like, I'm like, stop, chill, blah, 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 blah. You're not stronger than me. Stop doing this stuff, you know, because I didn't want her. I shouldn't have done that. I should have just called the cops and just waited for them right after I was called. Oh, that was too much stuff.
Was that her car? I mean, was it y'all's car or your car?
It was okay. I put $4,000 on down to the car. I had a 2018 Ford Escape. Yes, I traded it in with the $4,000, and I had her as a co-signer. So she co-signed for the vehicle. By her co-signing, and we get into this little argument or whatever, and I was going to my mother's house. She felt that she didn't want me with the car over there because she didn't want nobody else driving the car. So that was the dispute right there. But I'm telling her I'm not going to let nobody drive the car. It's in my name and her name. And I just needed a break. I just needed to get away for a second, you know, because I don't like altercations. I don't like to put myself in a situation where I feel like I'm going to violate or do something. So as I was trying to leave, it exacerbated because she didn't want me to leave, and she thought that I was going to be gone forever. And that was not the case. I went to go put a restraining order to protect myself, and in the process called my PO, let her know what happened, sent her the pictures and stuff. And by me doing that, my girl, she had an air tag in the car. So she saw me going to the courthouse. And when she seen me going at the courthouse, she said she came there. She saw my sister's car and the car that I have there, because she left the air tag in there. So she knew where we were. She thought I was trying to take her kids from her. So she sent the video to my parole officer of me pulling her out of the car. I didn't know it existed.
Okay. All right. All right, let's we'll come back if we've got some more questions and talk to you. Let's hear the folks that want to speak on your behalf. Okay, we got your brother, your niece, and your mother. Let's hear from the brother first. Kenrick Broussard. Mr. Broussard, are you on Zoom with us?
Yes, sir.
Well, tell us why we shouldn't revoke Mr. Brandon Broussard, your brother.
Well, how y'all doing today, first of all?
Good, sir.
My brother's, I think after he done his time, he came out, he's been on the right path. He's searched for jobs. He's taken a couple of jobs. He's been doing what he's supposed to do. He's been following the rules. I know he's told me about a couple instances with this girl that he met, and you know, I really told him that he shouldn't really jump into. I didn't think he shouldn't be jumping into a relationship fresh out of prison, because you know, saying work on yourself first, get yourself together first. But above all that, he still did it. You know, I can't blame him for having his feelings, but I understand what he's going through. And you know, I see him a lot of times. He tried to resist. He gave her a lot of chances. You know, she's aggressive. I thought she was aggressive at times, and that stuff I don't think you need as a felon. You know, you're getting out trying to get your, especially being on parole. You know, he had a good job lined up. He passed all his tests. You know, he passed all his regulations that they had set for him. Passed his urinalysis, and he was on his way to a good job. I thought, you know, and I believe by her seeing that he's on that, he's gonna be independent. I think she didn't want him to be independent. She wanted him to depend on her, from what I seen.
Okay.
And the conversations I had with her. But I don't think he deserved to be locked up again. I think he been out behaving, doing exactly what he's supposed to do. You know, that was just an instant that she used. I believe she used that to keep control of him.
Okay. All right, thank you, sir, thank you for your comments. Let's move on now to Miss, your niece, Kanya Edwards. Kanaya Edwards. Miss Edwards?
Hi, how are you?
Fine. Fine.
Okay, I'm here to support. I have over the few months I have heard a few situations that have gone on that have transpired. I don't believe that he should be sent back to jail like my other uncle was saying. He has gotten out and he has been trying to better himself. You know, by finding different jobs and just different things. He does have, before he got into this altercation, he did have a job offer offshore waiting for him. He did have a job offer offshore waiting for him, as well as one down here in South Carolina, because he does have his CDL. And we have a family-owned company down here that was trying to offer him a job as well. But besides the altercation that he did get into, you know, he has been trying to better himself. I don't feel as though he should be sent back to jail. I think he just needs to stay away from her. I don't feel like that one mistake should, you know, have him sent back. He's been away from our family for so long already. And I just don't want to see that happen to him. So I am here to support him. I do have my mom here, his little sister, my mom. She wants to speak as well, if that's fine.
Yes, it's her turn. So Ms. Montgomery, it's your turn to speak.
Oh, no, that's my grandma. My mom's here with me right now.
Okay, well, just three people can speak. So do you want to say your mom or Miss Montgomery?
Miss Montgomery.
Yeah, this is Brandon's mom. My name is Terrella Montgomery.
Okay.
Good morning. Good morning, sir.
Good morning.
Yes, I'm in very support of my son, and I feel he does not have to or go back and be involved with this young lady, because it has not, it has not benefited him at all. He did go to the bailiffs for offshore job. I have spoken with the man. His name is Mr. Robert, and he says whenever Brandon get out, he still has all his paperwork, and he still holds a job for him, which is an offshore job in the kitchen area. So I am in support of him and helping him when he get out and everything. And Mr. Robert is looking forward to hiring him for the job. He passed everything, all his paperwork. He passed the physical part. He passed the urinalysis and everything. So they just waiting on him.
Okay, thank you. Appreciate you, Mr. Montgomery, for getting on the line with us and letting us know that.
Yes, sir.
Thank you, ma'am. Okay, let's see, Mr. Broussard, I've seen the video and I've listened to you and listened to your supporters and all of that. And I don't want you to have to go back to jail till 2030 on this deal. I don't think you want to either. This is one of those odd cases where you're pleading guilty, but we're finding you're not guilty, basically. Anyway, so I don't know about your court case. I don't know what they're going to do with that. But providing, I want you to stay away from that woman. She doesn't want to pursue charges. We've all seen the video, and I can speak for myself only. But I don't know that it was you didn't hit her, you didn't kick her, you didn't choke her. You just trying to get her out of your car, and I'm not going to say it was justified doing that, but you've already said what you would wish you'd have done, and I wish you'd have done that too.
Yes, sir.
You've already served some months over this deal, and so let me ask my panel if they have any questions before I vote.
I don't have any questions.
Ms. Ledoux? Okay, my vote is that you not be revoked today. Now, providing you stay away from that woman. She doesn't want you around her. Y'all got bad chemistry. I don't know what the deal is, but it's bad chemistry. And so stay away from her.
Yes, sir.
Is that okay with you? You
Yes,
agree
sir.
with that?
I agree with that. Yes, sir.
Okay, my vote is to not revoke. Ms. Jerry?
Mr. Broussard, my vote is not to revoke, that you have no contact with the, Ms. Bell, I believe her name was. Also, you've acknowledged, while you were incarcerated, did you take any anger management classes?
Yes, ma'am. I've taken 3 anger management classes. I've taken stress management. I've taken character counts. I've taken human relations. I've taken a lot of courses.
That's probably why you were able to articulate what you should have done.
Yes.
Versus what you did. Okay, so I'm not going to put any additional programming on you, but have no contact with Ms. Bell. Thank you.
You're welcome.
Okay, Mr. Tillis?
I concur with Mr. Prater and Ms. Ledoux.
Okay, sir, as of 9:54 this morning, you no longer have a hold on for us. And so you'll be getting the paperwork there. I don't know what they're gonna do with the case, or if they've dropped it. I don't even know what the status of the case is. But anyway, you are not revoked this morning. Just go get your job like you're doing, stay straight like you're doing, and stay away from that woman.
Thank y'all so much.
Yes.
Wow. All right. Well, that's stay away from that woman. You know, that's probably good advice for a lot of people, especially when you've been in prison. As his brother said there, I believe, I think the first thing that he should have done is, I don't think it should have been to get into a relationship. That's usually not the optimal path when you first get out of prison. Oh well. Sagely advice sometimes we offer here at the Courtroom Files. It is TCF Live. It is Tuesday. We've got a lot of courtrooms that we're monitoring, and there's certainly some activity going on out there. Let's head to, where haven't we been in a while? I'll tell you what. Let's go to Fulton County. And this is the State Court of Fulton County in Georgia. And see what's going on down there this morning.
Negotiated plea.
Good morning, Your Honor. Yes, it will be.
Thank you. Good morning, Mr. Thrasher. I'm Judge Eric Morrow. This is the state all-purpose calendar. Can you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can place your hand down, Mr. Thrasher. Thank you. Good morning, Ms. Evans-Battle.
Good morning, Your Honor. As to count 1, we're asking for 12 months, that he serve 90 days, a credit for time served, the balance suspended, that he stay away from the Chevron and subway stations at 1337 Virginia Avenue, East Point, Georgia. Thank you.
Ms. Tucker.
We do so stipulate for the purpose of the plea, Your Honor.
If nothing further, Mr. Thrasher, it's my understanding that in case 25 CR 008326C, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Could you repeat it?
You've been represented by Ms. Tucker here. Are you happy with what she's done for you?
Yes, sir. Yes,
You understand that you have a right to a trial by jury on this charge, and that because you're pleading guilty to it, you're giving up that right?
All right.
Is that a yes?
Yes.
Has anyone forced or coerced you to plead guilty?
Nah.
Okay. I'll accept the plea as negotiated, Mr. Thrasher. You know you can't not go back to that Chevron or Subway, okay?
All right.
All right. Good luck to you, sir.
Right, James. Come on. All right, next we got 45, Mr. Smith, Stafford Smith.
Okay. Also a negotiated plea.
Yes, Your Honor.
As to the criminal trespass, 12 months,
Oh,
serve 60.
just one moment, Ms.
I'm
Evans
sorry.
Battle. Good morning, Mr. Smith. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm? Thank you. Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down, Mr. Smith. Thank you. Yes, now, Ms. Evans Battle.
12 months, Your Honor, serve 60 days, credit for time served, balance suspended, and that he stay away from all MARTA locations. Thank you, Your Honor. I ask that he stipulate to venue, identity, and a factual basis for the plea.
Does he have a permanent ban from MARTA?
I'm not sure if the ban is permanent. I can't remember. I just know that there was a suspension in place at this time.
Okay, thank you.
Your Honor, he does have a suspension for MARTA. I would ask that the language of the offer be changed to stay away from MARTA in accordance with any current suspensions, because he is interested in going through a appeal process with MARTA to get that suspension potentially lifted. And he stated it would help him with finding work to have that transportation available.
Would it be fine, Ms. Evans Battle, if he were to abide by any active MARTA suspensions?
Yes, Your Honor.
Okay, so
Thank you.
thank you. Okay, so with nothing further, counsel, Mr. Smith, it's my understanding that in case 25 CR 008299J, you wish to plead guilty to criminal trespass, is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Smith. As long as there is an active MARTA suspension, you cannot go back to MARTA. If the suspension is lifted or if it times out, then you can go back, but make sure that you don't go back while you have a suspension or you'll be in violation. Okay?
Yes, sir.
All right. Good luck to you, Mr. Smith.
Yes, sir. All right, next we got number 53, Mr. Warren.
Also a negotiated plea.
Yes, Your Honor.
Good morning, Mr. Warren. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you, Mr. Warren. Ms. Evans Battle?
Yes, Your Honor, 12 months, ask that he serve 90 days, credit for time served, balance suspended, that he stay away from 2907 Main Street and East Point, which is a CVS. Ask that he stipulate to identity, venue, and a factual basis for the plea. Thank you.
We do
Ms.
so
Tucker?
stipulate for the purpose of the plea.
And is Ms. Tucker, is this a time served plea?
No, Your Honor.
Does he have additional time?
He would have additional time. As of now, he has credit for time served of 14 days.
So I take it that my concern is that this is a giving false information to law enforcement that's not that doesn't have any underlying charge with it, such as disorderly conduct or anything of that nature. There's no trespass with this CBS. Were there some other charges associated with this that have already been disposed of or that were pending in another court? Give me a little bit of the background.
Okay, let me get over to that screen, Your Honor.
While you're doing that, Ms. Evans Battle, Ms. Washington, good morning. Are you with me?
I'm here, Your Honor.
May I have Mr. Warren's history, please?
Yes.
Ms. Tucker, is he being held on anything other than this charge?
He does have a separate felony case that he's currently being held on a no bond status.
Okay.
And Your Honor, I am ready. There are 95 arrest cycles. As she mentioned, there appears to be an open theft by shoplifting felony from September of last year, an FTA from last year, an FTA from 2024, an arrest for criminal trespass in 2024, no disposition was listed, an additional arrest from 2024 for misdemeanor theft by shoplifting, no disposition listed. There appears to be a history of felony probation violations for theft by shoplifting, willful obstruction. There are several arrests for theft by shoplifting, felony and misdemeanor, an FTA in 2020, an FTA in 2019. There was a NOLO plea in 2018 for theft by shoplifting misdemeanor. Additional history for probation violations regarding felony theft by shoplifting cases.
Okay, thank you. Thank you, Ms. Washington. I appreciate it. Does he need a social worker visit to assist with housing, Ms. Tucker, once he's released?
Mr. Warren, do you have housing?
No.
We can have him
Okay.
speak with our social worker who should be present in the courtroom there.
Okay. All right, I have enough information. Thank you, Ms. Evans Battle, for seeking that for me. If nothing further from council, Mr. Warren, it's my understanding that okay, I can't go forward courtroom 2 until I can either get you all muted or okay. Mr. Warren, it's my understanding that in case 25 CR 008327C, you wish to plead guilty to giving false information to law enforcement. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time? Say it again for me.
No.
You've been represented by counsel. Are you satisfied with her representation? Mr. Warren, did you hear my question?
Yeah, I said yes.
Okay. You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Mr. Warren, you understand that once you get out that you cannot go back to that CVS. I'm also going to have a social worker talk with you. So before you get out, they can give you some information regarding housing that might be of assistance. Good luck to you, sir. You're welcome.
Mama Joan, Grandma TCF, thank you for the $10 super. Really do appreciate that. Also, one other thing to note here in the chat. We love our chat. We love everybody in the chat. And there's very few rules in our chat. We just ask that people be respectful. But the other rule, and this isn't a Dan rule. This is a Mike rule. Dan can do it as he wishes. But when you come in here and you're one of the AI slop imitator channels of ours, that's going to get you kicked. Sorry, we don't put up with the AI slop, especially people that that are the imitators of this channel. No, we do not support that. Because we're actually live and human curated, and that's what we do here. So back to the State Court of Fulton County, and thank you, Ashley, for taking care of that matter. And we'll send the rules set up to the big boss Dan, but that's how it
Give me the
is.
phone number, please.
So two or three? 612 or 613? 612. 612, it's 404-612-2060.
Okay. So we'll be back with you, Mr. Barber.
Thank you.
Ranger. And if we can do number 9, Mr. Davis? Yeah, do.
Negotiated plea, Mr. White?
It is, Judge. Good morning.
Oh, good morning. Good morning, Mr. Davis. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Better true.
Okay, you can place your hand down. Thank you, sir. Yes, Miss Evans Battle.
Yes, Your Honor. As to count 1, 12 months, served 90 days, balance suspended. As to count 2, 12 months, served 30 days, balance suspended. Ask that he stipulate to identity, venue, and a factual basis for the plea.
So stipulated, Your Honor, nothing further.
Okay. Mr. Davis, it's my understanding that in case 25 CR 008288B, you wish to plead guilty to criminal trespass and one other misdemeanor offense. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I accept the plea as negotiated, Mr. Davis. Good luck to you, sir.
I got one. I appreciate it. Thank you, Your Honor.
All right, ladies and gentlemen, it's a choose your own adventure time here at TCF. Do you want to go to Judge Simpson? You can put a 1 in the chat for that. Next. Do you want to go to Louisiana, back and see what's going on with Louisiana Board of Pardons and Paroles? That's 2. Or do you want to go back to see what's going on with Judge West? 3. Now, I'm not saying we won't go to all of those, but what do you want to do next? We'll give you a few minutes to put that in the chat, and then we will do what you say. Democracy rules here at TCF.
About the truth?
I do.
Okay, you can place your hand down. Thank you, sir. Ms. Evans Battle.
Yes, Your Honor. On the 7511Y, count 1, 12 months, served 30 days, credit for time served, balance probated, complete the FDIP, no further contact with Kamisha Candy, and stay away from 5500 Oakley Industrial Boulevard in South Fulton. Count 2 would merge into count 1. As to count 3, 12 months, served 30 days, credit for time served, no further contact with KR, a child. As to reckless driving on count 4, 12 months probation, defensive driving course, a fine in the amount of $300. This is a global recommendation with case ending in 259Y. As to count 1, simple battery, family violence, 12 months probation, 40 hours of community service, no further contact with Kamisha Canty, Kamaya Robinson, or KG, and GW. I'm sorry, that's KR and GW, which are the 2 children in the case. As to count 2 and to count 3, state will move to no across those cases This as part of the negotiated plea agreement. Acts that he stipulate to identity, venue, and a factual basis for the plea.
Ms. Evans Battle, on my calendar, position number 39 has 5 counts. The last 2, reckless driving and reckless conduct.
We'll merge the reckless conduct into the reckless driving, Your Honor, as to count 5.
Thank you. Mr. White.
Your Honor, we do stipulate for the purpose of the plea to a few things. We would, first of all, we'd like to enter the reckless driving as a NOLO. We'd also ask the probation go to non-reporting once he completes all of his requirements. Just that's all from the defense at this point.
To you, any objection, Ms. Evans Battle, to the NOLO?
No objection to the NOLO. But we would object to going non-reporting. Both of these incidents involve the same victim. In fact, we did have an opportunity to hear from the victim, and I didn't because it wasn't part of the negotiation. The victim is asking also that he stay away from her dad's located at 9100 Cascade Palmetto Highway in Palmetto, Georgia. It's my understanding that she's taken out a TPO, so we do want to make sure that there is continuous reporting probation in this case. If the court wishes to have some facts, I will go over to that screen.
We just stipulated to a factual basis, Judge. Point is, he's got the 24 episode family violence intervention program, defensive driving, fine to pay, community service. Anticipate it's going to take most of that time anyway. And all we're asking is to go non-reporting, not that his probation terminate. And the TPO, the alleged victim is will cover everything else, Judge. So
Okay. If nothing further from counsel, Mr. Robinson, it's my understanding that in case 25 CR 007511Y, you wish to plead guilty to battery, cruelty to children in the 3rd degree, and NOLO to reckless driving. And in case 25 CR 008259Y, you wish to plead guilty to simple battery family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty and NOLO?
No,
I'll accept the guilty and NOLO pleas. Mr. Robinson, let's see, you understand that you can not have any contact with Ms. Canty or her family. That means no contact whatsoever. Obviously no personal contact, no internet contact, no social media contact, no texting, no contact whatsoever, or you'll be in violation. Given that it's going to take you some time to get through these requirements as an incentive to make sure that you get this done in a timely fashion, if you make all of your probation and do not miss any probation dates, if you complete all of these within a time frame, if you complete it before the end of the probation, I'll have the probation go to non-reporting. But if you miss some probation times, if you don't report, or if you don't complete it, you'll be on probation for the entire time. All right. Good luck to you, Mr. Robinson.
Take care.
All right, democracy rules here at TCF, and by popular demand, We're going back there. You never know what's going to happen. It's the Louisiana Board of Pardons and Paroles.
Good morning. The time is 10:10 in the morning. The date is January the 6th of 2025. My name is Steve Prater. To my right is Jerry Ledoux. To my left is Chuck Tillis. We're at the Department of Corrections headquarters in Baton Rouge. We are talking to DeQuante Polly at Richland Parish Detention Center. Is that correct? Are you Mr. Polly?
Yes, sir.
Okay. Is anybody in the staff with you from Richland Parish?
They standing right outside the door, sir.
Okay, so they're not in the room. That's okay. Mr. Polly, what is your DOC number?
580175.
Okay, and what, do you have a waiver form in front of you that you signed?
Yes, sir.
Okay, did you sign that and you understood all of that, correct?
Yes, sir.
Okay, Miss Cherry Ledoux to my right is handling your case this morning. And so she's gonna be asking you some questions to go over the conditions of your parole that you're suspected of violating. So, Miss Ledoux?
Yes, Mr. Polly, I'm going to read out the allegations and ask you to enter a plea of guilty with a statement, or not guilty, okay? First, we have rule violation number 2. You were directed to report to your probation officer monthly. You failed to report the months of July, August, and September 2025. How do you plead?
Not guilty.
Okay, condition number 4. On 9/9/2025, you were arrested by Delhi Police Department for committing the offense of aggravated battery, cruelty to a juvenile, and domestic abuse battery. How do you plead?
Not guilty.
And number 10, you are in arrears $1,320 on your supervision fee. How do you plead on that?
I'm in the reels. I'm guilty on in the real.
Mr. Polly, I want to focus on rule violation number 4. You do have a court date coming up on that, don't you?
Yes, ma'am.
Do you have an attorney that you're going to hire for that?
No, ma'am. I'm using a court-appointed attorney.
You have a court-appointed attorney.
Yes,
Okay.
ma'am.
Have you been to court at all on this yet?
Yeah, I had a arraignment. At the arraignment, they dropped cruelty to a juvenile and aggravated battery. We came up on the agreement to that she'll drop the domestic down to disturbing the peace and give me anger management classes for it.
Okay, so what is going to be determined at the trial then?
It's on January the 26th when I go back to court in front. She said I had to come in front of a judge to actually get it done because I had the arraignment on Zoom like we doing right now.
Okay. So who was the victim in your aggravated battery? Your girlfriend?
No, it was with my daughter, my 16-year-old daughter. I was trying to discipline her with a belt, but she was fighting me back at the time that I was disciplining her. And when they charged me with aggravated battery, I guess saying that I hit her with the belt or whatever.
Okay.
But they did dismiss both of the charges against my daughter. I'm guessing the domestic against my girlfriend. I don't know if they trying to charge me with the domestic against my girlfriend or my daughter, because I know you can have a domestic on anybody in the household.
Yeah, because you have been convicted previously of aggravated battery.
Yes, ma'am, in 2012.
Yeah. So have you ever taken any kind of anger management or parenting classes?
No, ma'am.
Do my colleagues have a question?
Yeah, why were you disciplining your daughter?
Because I had just got out of work and she walked to the store with me. She decided to call her mom and tell her mom that I met somebody at the store, which I did not do. So when we got back to the house, I was trying to tell her what she was wrong at. And she jumped up yelling, saying disrespectful words or whatever. So I grabbed the belt to discipline her. But when I decided to do that, she decided to want to fight. So
That's your daughter?
yes, sir. This is my 16-year-old daughter. She turned 17 while I've been incarcerated.
Um, okay, I can understand that. I can understand.
But as I was saying though, my girlfriend, when they talked to the DA of Richland Parish and cleared it all up and told her exactly what happened, told her I didn't hit her and told her I was disciplining my daughter and she was fighting me back. They dropped all the charges, but the domestic said when I come on the 28th that they was gonna drop the domestic down for it wouldn't bother my parole and give me anger management classes for all of it.
You're willing to take some anger management classes?
Yes, sir.
I have no questions.
Okay, we have Miss Thomas here who says she's your girlfriend on Zoom and wishes to speak. Now would be a good time to entertain her comments.
Yes, ma'am.
Okay, Miss Thomas, are you on there?
Yes, I am. How y'all doing today?
Good, thank you. Go ahead and tell us what you'd like us to know.
Yes, ma'am. I just want to, well, and all the Quincy is a great father. He assists me with our disabled daughter. He helps me. He's a provider of the home. He helps me a lot, with the girls and keeping up our bills. It just was a big misunderstanding with our family that night. And I just want you guys to know he's not a bad person. He's a good person. If y'all will just, let him be able to make fun or whatever. But he's a great person. Everything just transpired, went bad with our daughter that night. But and all, he's a great father. He provides for the kids and me as well.
But you did call the police and ask for them to come and remove him that night.
Yes, ma'am, because I didn't want it to get heated. Like I didn't want the situation to go further than what it was. Because it was the heat of the moment.
And you told them that he punched you in the face several times.
No, ma'am, he didn't punch me in my face.
Okay, let's say Ms. Thomas informed the officers that he punched her several times. So did he punch you several times?
No, man, he didn't punch me. The Quinte he had the keys. He didn't punch me. When I was talking with the officer, because this is the officer that I usually talk to. Was talking with him, like saying like if this would have happened, maybe this, but no, he didn't punch me, man. I was just had scratches on my hand from the keys.
So how many times have the officers been called to your house about domestic issues?
No, it's been a minute. It's been a minute since they've been to our house. He just know me from, just being, around.
Okay, well, this is very concerning to me.
Jerry, I'd like to call executive session.
Okay,
Okay, we've got a motion for an executive session by Mr. Tillis.
I'll second.
And we have a second, and there's no objection to it, and we'll be in executive session. We're gonna go in executive session for just a few minutes, and then we'll be back, and let you know. We gotta talk about some
Well, I
procedures.
want to ask one question before we go in. The 14, 15-year-old daughter is your biological daughter, is that correct?
Yes, ma'am.
Okay, Miss Thomas is your common law wife, is that correct?
Yes, ma'am. We have 3 kids together.
Okay, I'm in law one. Okay, so that's what I needed to ask. Okay, thank you.
We're going to go into executive session to talk about how dumb you are. I got to tell you something. This is one of those cases that just makes your blood boil, and why the Louisiana Board of Pardons and Paroles is always so entertaining. But I think this is a no-brainer right here. We're going to see what they come up with out of their executive session. But when they ask the question, if anybody ever asks you the question, hey, how many times have the police been to your house for domestic? And you go, well, I don't know. It's been a minute. Yeah. Okay. Yeah. Not a great answer. Also, when she says, oh, it's the officer I usually talk to. Oh boy. Oh boy. All right. Well, there's a lot going on here. I don't know. This could be a topic on Sidebar. Speaking of Sidebar, tonight, 8 p.m. East, 5 p.m. Pacific, new laws are on the books around the nation. We're going to talk about some of the silly laws, the new laws, the weird laws, the whatever that's out there. We're in the Wayback Machine just a scant bit here, and we're going to see if we can push this forward. Oh, there we go. And get the results of this executive session. Here we go.
And do I have a motion to go back into regular session? Got a motion and a second. There are no objections, so we're back in regular session. As I said, it's 10:23 on 1/6 of 2025. We're talking to Mr. Polly. Gary, Mr. Ledoux, excuse me, would you go ahead and continue?
Mr. Polly, when you were incarcerated, did you take anger management classes?
No, ma'am. I took, yes, ma'am, I did. I took anger management. I took parenting, and I took one more class when I was in East Baton Rouge worker lease.
Okay. How do you feel like you handled the situation with your daughter?
I feel like it shouldn't have went as far as it went. But the only reason it escalated is because I was trying to discipline her and she fight me back. I mean, if she fight me, she fight me. I can't just let my daughter just sit there and fight on me, punch on me. So in the mix of me trying to discipline her when she was fighting back, that's when the officer said it was a glass table she never went through a glass table. We already had a glass table in our home that had a crack in it. And she's a heavy-set young lady, so when she leaned up against the table, it just scattered. It didn't bust everywhere. It already had a crack, and it just scattered on out.
Okay. So, Mr. Polly, because you have a history of aggravated battery, my vote today is going to be in lieu of revocation, pending the charges being dealt with in court, open court 128. If that goes as you have indicated it's going to, then my vote is to, in lieu of revocation, send you to a facility in DOC that has a Duluth domestic abuse violence class. And then after that, you would be released.
Could you make me understand that better, ma'am?
Yes, sir. So you have to go to court first. You have to go to court, and you have communicated that you feel like these are going to be pled down and dealt with in a certain way.
Yes, ma'am.
After that happens, then my decision would kick in. That in lieu of revocation, instead of revoking you to go back to your 28 date, you would be sent to a facility to take a course, and it may take you 6 months to take that course. I'm not sure how long it takes. But you would be sent back to a DOC facility that offers a domestic abuse violence class that you would take, and then you would be released back on parole.
Yes, ma'am.
Okay, Mr. Phillips?
Ms. Fowler, do you understand that you're just gonna get a refresher course? And that's better than going back to jail, I think.
Yes, but I still will be incarcerated though, huh?
It's gonna be shorter. If I revoke you, you're staying a lot longer, okay?
Yes, ma'am.
I think you did. I wouldn't let my daughter do what your daughter did either. And I think if you get a refresher course, it just helped you to, and you did a good thing by not letting it escalate, and your girlfriend also not let it escalate more. So all we want to do is be satisfied that if you get a refresher course, you'll be a lot better equipped to deal with a situation like that again.
Yes, sir.
6 months is shorter than more time.
And we don't even, 6 months, we don't know.
Yeah. Right. Do you understand?
Yes, I do.
Okay, all right, and so that's Mr. Tillis's vote is to concur, is that correct?
Concur with Ms. Ledoux.
Okay, and my vote also is to concur with Ms. Ledoux, and I think you may not realize that you get a good deal, but we don't want to see you again, okay? We want to really take this course seriously.
Yes,
And that, in this, as of today, you're in lieu of revocation, you'll be sent to a facility that offers the Duluth domestic violence training. Once completed, you'll be released back onto supervision. The time is 10:28 in the morning, end of the hearing.
Here's how you handle that. You want a refresher course, it's pretty simple. Don't put your hands on somebody else. Don't take a belt to your 16-year-old daughter. I don't care what kind of attitude she may have. You don't take a belt to her. What is going on in Louisiana today? It's a Twilight Zone Tuesday here on TCF. All right. It's always entertaining. Well, that's why we loved it. It was not a mistake to go there, but boy, oh boy, that was something. All right, let's go to Michigan, because by second popular demand in our Choose Your Own Adventure earlier, let's go and see what's happening with Judge Simpson. We haven't said good morning to him yet. So let's see what's happening there.
All right. Okay. Thank you. Take care and Happy New Year to you guys. Court does call the case. Gil Sanford versus Susie Norman. Miss Norman is in. There she is. Your name, sir?
I'm Gil Stanford.
All right. And Ms. Norman, can you hear me?
I can.
All right. And where are we on this case?
I submitted to the court a bunch of information that you requested in regards to the payments that she had made, the condition of the full correction from the previous tenant.
Yeah.
And then the condition when she moved in, and then also the condition when she moved out. Have you had a chance to review those?
Well, I've looked at what's been submitted. Ms. Norman, did you get a copy of these?
I did receive a copy at the end of December, the 30th, the 29th and the 30th. I received.
So you sent a copy of these to her?
I sent her photos and the copy.
All right.
Sent to the court.
And Ms. Norman, do you have a response to these documents, or is there additional documents that, now that you've seen these, that you would need to provide to the court?
Well, I do object to the damages that he's claiming. I would like to just say that I thought that the matters between Mr. Stanford and I concluded in October of last year. So and we had an agreement, so I'm surprised that we're still, going through this. But I had a chance to look at the photos and I do object to them. And if this is going to proceed forward, if I could ask the court for time to be able to submit my evidences.
Okay, well, all right, and I guess that's what I was asking. So you have, do you have other documents that you believe contradict what the plaintiffs provided?
I do. And
Okay.
photographs as well.
Okay. So how soon can you gather all of those, provide a copy to the court, and also to the plaintiff in this case?
Well, I'll take what the
Can
court.
you do it in 2 weeks?
I can.
Okay, so here's what I'll do so that we don't waste a lot of time today, sir, is I'm going to let her submit that so you can take a look at that and the court can take a look at that, and I can look at everything in context of what the parties are saying. Yeah. And so what I will do is I'll adjourn this matter then to these matters to January 27th, 2026, 9 a.m.
Judge Simpson.
Okay. And I'm just going to indicate that the documents from Ms. Norman should be provided by the 20th of January. Okay, so the sooner you get them out, the better. How did you send the documents, or did you mail them or email?
I mailed them.
Okay, so you can do it the same way. Just make sure to mail out a packet to them. Okay?
Okay.
All right.
Can I ask a procedural question?
Surely.
So there's also an issue of my security deposit. Would that be something that is brought up within this case, or is that something separate when this is finished?
It would be brought up in this case because it would be an offset. It could potentially be an offset to any damages or other claims that he may have.
Okay.
Does that make sense to you?
It does. The last time.
All right. So here's the thing, folks, with the two of you. You've both been very, very good. So I'm going to try to resolve everything that you guys have so that whichever way it goes, you guys are done.
That would be great. Thank you so much.
Okay.
Yes.
And what I was just going to indicate, you're sending that out to him, and Mr. Stanford, if you don't get something, say by so that we can try to be ready to go by the 21st or 22nd, then just send an email to my office to let us know, so that if there's a delay in mailing, or if it's not all here and everybody's not going to look at it, I'm not going to drag everybody back down here. We'll try to figure out something.
All right.
Yeah. Okay. All right. Thank you, folks.
Thank you.
Send out notice.
Yes. For the 27th. Yes, we will.
Thank you.
Thank you.
And it's your 11, and everyone is here.
The courtroom
Everybody's
files
here?
live.
All
It's
right.
Tuesday.
Guys,
We're hanging with Judge
you guys
Simpson
come
for a
up.
few
Give me
minutes.
a couple minutes. I got to go take care of a
Or
phone call, and then I'll come back.
Or we are
Hopefully be
not.
short.
Looks like he is going to
What? Yeah.
have a little executive session of his own there. All right. So while that goes on, we'll of course keep an eye on what's going on with Judge Simpson's court. Let's see. I see Judge Stevens has a trial going on, so we can't really go there. But let's go ahead and go back because you folks asked for it earlier. Third on your list. And of course, we have other places that we're going to go as well. But here is Judge West. Looks like another contestant coming on down.
Thank you, Mr. Rojas. Good morning. Are you Heriberto Chavez?
Yes.
And in clause number 25, DCCR 0559, Mr. Chavez is charged with deadly conduct, discharging a firearm from May 8th of 2025. What is the announcement?
We signed a rejection.
Oh, I'm sorry. Mr. Chavez, what that means is that if you go to trial and you're found guilty, the range of punishment is a minimum of 2 years up to 10 years in prison. Do you understand?
He understands, Judge, he just thinks the offer is too high right now.
So the state, I have on the computer tablet a plea bargain rejection that has your signature on it that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for a 6-year term in prison. It says or, but.
We were I think we've been discussing a possible cap, Judge. I think that's
Okay, just the 6 years.
Today was an offer of 6 or the caps. Was my
What was the cap of what? Y'all
You didn't write it down
I'm
there.
sorry, it should be 8.
Or a cap of 8 years in prison, which is where you would leave your punishment up to me. I could not give you more than 8. I could give you 8 years. I could give you less. You have an absolute right to have a jury determine if you're guilty or not, and for that jury to determine your punishment if you're found guilty. I want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter a plea of guilty. And do you understand all of that? Do you have a question?
I want to try, but I don't want to accept the offer right now.
Mr. Nichols, is there any reason to believe that the state's offer would change?
No, Your Honor.
So you don't have to like the offer, but the offer is what it is. So your option is either to let a jury decide or to accept that offer. And so what do you want to do?
Wait.
There's no waiting. You have to make that decision today.
Try.
All right, I want to make sure you understand that after today, I won't accept that plea agreement. And do you understand that? Answer out loud.
Yes, after today, you want to accept that agreement.
Okay. Mr. Chavez will get your case set for trial. Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial quicker. Is that okay with you?
Yes.
All right, so Mr. Rojas, you're released. Mr. Chavez, we will appoint someone today. They should be out to see you very soon to begin preparation for trial. You can go back with the bailiff. Let's see, Lee Coney. Mr. Rojas?
She said,
Oh, well, we don't have a.
she's gonna ask for a new lawyer and a reset, and then I think it's a motion that my suggestion is to take this in a motion, and see what happens there. But
All right, let's
it's
get
up to
Lee Coney, we'll do that. It's like they're both, the new offense is a state jail as well.
Yes.
So we can go forward with the motion first. All right, let's see. Okay.
Well, she brings down the next contestant, Barbara. Thank you for the gifted membership. I think Barbara was trying to get Kelp a gifted membership, but there's lots of possible targets, and you don't always get them, but sometimes we do with those random gifted memberships. But thank you, Barbara, so much. Really do appreciate that.
I just signed the dismissal on Charles Tigner, so he's free to go back as well. Good morning. Are you Lee Coney? Yes, ma'am. And Miss Coney, you've got two cases. One you're on probation for in cause number 24 DCCR 1600 on probation for theft of property with previous convictions. There's a new indictment that's been handed down in cause number 25 DCCR 1274. You're charged with possession of a controlled substance, also a state jail felony. It's my understanding that there is no agreement in either of these cases. Is that correct?
That's correct, Your Honor. I was speaking with Ms. Coney this morning and yesterday, and she has a request to make of the court. She would like to have a new attorney.
Well, Ms. Coney, you don't get to pick a new attorney. Mr. Rojas is an excellent attorney. He's, I'm sure, talked with the assistant district attorney, is giving you that information and advising you. And so if you want to take some agreement, that's fine. If not, what's going to happen is today we'll go through that motion to revoke your probation. And I'll get pleas of either true or not true to those allegations. Then we'll reset that case for a sentencing hearing. I'll determine if you violated your probation. If I determine you have, I can either continue you, I can revoke you, I can do whatever at that point. And then depending on what happens on that case, I guess we'll see what happens on that new offense. And so do you want to talk to Mr. Rojas about that agreement, or do you want to go forward and leave it all up to me on your motion, I guess? With what? Just pleading open to the court? Raise your right hand the best you can, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Yes. Thank you. Will she waive the formal reading of the motion?
She will, Your Honor.
Ms. Coney, in 24 DCCR 1600, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 29th of 2024 for the state jail felony offense of theft of property with previous convictions, and that was a 5-year deferred probation. Is that correct? Yes. The motion alleges that you violated your probation. Count 1 alleges that you committed the new offense of possession of a controlled substance, a state jail felony, November 1st of 2025. And is that true or not true? No. Count 2 alleges that you committed the offense of possession of a controlled substance, penalty group 3, and I'm guessing that's a misdemeanor offense?
I think so, Judge. The case is not yet, that case has not been filed.
Okay.
It's awaiting testing right now. It's in progress.
Okay. And I'm not sure if that's a misdemeanor or not then. Penalty group 3, less than 28 grams on November 1st of 2025. And is that true or not true?
I'm sorry.
It's the same date. It's just a different drug. November 1st of 2025, when you were arrested, it was for possession of 2 different types of drugs.
No, ma'am. No,
Okay, so not true to count 2. Count 3 alleges that you failed to report to the probation department July 24th, August 21st, October 8th, and October 29th of 2025. And is that true or not true?
I'm listening. He was trying to tell me something while you were talking.
So count 3 alleges that you failed to report to the probation department on July 24th, August 21st, October 8th, and October 29th of 2025.
That's true.
Okay. Count 4 alleges that you failed to never become intoxicated or under the influence of any intoxicating substance. Mr. Nichols, did you read that one?
Failed to never become intoxicated or be under the influence of any intoxicating substance.
In that on or about
March
19th, 2020.
I'll just drop 4, Judge.
Do you want to, I mean,
This isn't my file. I don't know the details
Well,
of the
let's don't-
violations, and I can't amend right now.
okay.
I don't know what.
What I'm going to do is at this time, I don't want it I want to know whatever allegation that is at the appropriate time.
I can see it here, Judge, and I can orally amend that. What it's supposed to allege is that she tested positive for cocaine on March 19th, 2025.
So any objection to the amendment reading in that on or about March 19th, 2025, the defendant tested positive for cocaine? Mr. Rojas? So count 4 alleges that you failed to never become intoxicated or be under the influence of any intoxicating substance, and that you tested positive for cocaine March 19th of 2025. And is that true or not true? Count 5 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
Not true.
Count 6 alleges that you failed to submit to alcohol and or drug screening on July 29th of 2025 at the direction of your probation officer. Is that true or not true?
It's true.
Okay, you'll get to explain later. Right now, just true or not true. Count 7 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true? I'm sorry?
Yeah, true.
And then count 8 alleges that you are behind in your court-assessed fees as of November 3rd of 2025 in the amount of $575. And is that true or not true?
As of November. On that day,
Yes, that's true.
Okay. Did you enter your pleas of true to counts 3, 4, 6, 7, and 8 freely and voluntarily? And did you plead true to those counts because they're actually true?
Well, with the payment, that my payment is caught up now.
Okay, I'll just take off number 8 and put not true on that one. So 3, 4, 6, and 7, did you plead true, again, freely and voluntarily?
Yes,
And because those counts are actually true?
yes.
All right, then I'm going to find counts 3, 4, 6, and 7 true. Find that you entered those pleas freely and voluntarily. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset the case for a hearing. I would anticipate, Mr. Nichols, that you would have some evidence with regard to the count 1, the new
Yes, Your Honor,
offense.
the state will prove up.
Do you think we would need more than an hour or so?
I wouldn't think so, Judge.
Okay.
Appears to be a traffic stop.
One or two, I guess, a 2 witness.
Yes.
We need
At least
lab.
2. Hour and a half, I would think.
Okay, we'll get it set for an appropriate day. Just everybody make a notation that it will be set for a hearing for that. Anything that you think is important for me to know, get that information to Mr. Rojas and he'll present it to me on your behalf when we come back. And if I can get an updated pre-sentence report, that would be great as well. Thank you, ma'am, for being here. You can go back with the bailiff. Oh, actually, come over here to the clerk. She needs your fingerprint before you go back with the bailiff.
It's the courtroom files live. It's Tuesday. Oh my goodness. Thank you so much for hanging out with us. Really do appreciate it. Let's head back up to Michigan. Now, this is someplace I like to go from time to time because we don't see her very often. When I guest host, I like to sprinkle in a little bit of Judge Shackelford. We'll see what she's got going on. We haven't gone here in a while, but sometimes she can be quite entertaining, and so we'll see if that's what's going on here. Make sure I have the everything unmuted and everything. So here's Judge Shackelford.
All right, this is 2529330OM, the People versus Christopher Haas.
Good morning, Your Honor. Deborah Schlossel on behalf of the defendant, Mr. Christopher Haas, who's to my right, state your name.
Name is Christopher Jason Haas.
Your Honor, we have reviewed the sentencing recommendation and we both signed it. We have no additions, deletions, or corrections. We do agree with what is set forth. We did have this plea was made pursuant to 771.1. We are asking that you honor that. Your Honor, it does say in there, well, I said there were no additions, deletions, or corrections, but there is a paragraph in there that says that my client was minimizing it, or that he doesn't take this seriously, or that he has no desire to make his life better. Exactly the opposite, Your Honor. He wants to make his life better. He's been applying for jobs. He applied for disability. He's got this health condition that, he had a seizure on his job and they fired him because of it. So it's not like he's blaming other people for his situation. He knows it's his health issue. But, Your Honor, we would ask the court to take into account that he does have this health issue. Your Honor, he knows what he did was wrong. He's very remorseful. He does not have a criminal record. I realize that these are 3 cases in one, but Your Honor, we have resolved them. You will not see him before you again, except to close out this case. He's going to do everything that's required by the court. He's very thankful he was able to work out this deal, that we were able to work out this deal with the city of Taylor. And Your Honor, he has something he would like to say to the court.
All right, go ahead, sir.
I am going to be completely and totally honest here. I never expected to be here before a judge. I do not condone my actions in any way, shape, or form. I do very much regret them. Unfortunately, I've made a stain on my infant and my toddler's life because they will one day learn of what I've done. And I was raised better than this. I made the mistake of allowing myself to think that what I did was going to help them. And I know that I am wrong. And I no longer see it that way. And I intend to follow all terms to make up for my misdoings here. I have no intention to ever reoffend. I don't know what more to say.
Well, I believe you,
Have to be
if that helps. I mean, I have someone in front of me who's no prior criminal history, no outstanding warrants, no indication that this is normalized to you or that this is something that you find socially or morally acceptable. You made a bad decision, right?
Yes.
But I will lecture you for just a moment on, you can ask your lawyer about this. We learned this in law school. There are 2 different types of crimes, right? There are crimes that are bad because the government says so, right? Like driving on a suspended license.
Yes.
That's bad because the government says you have to have a license, right? It's not morally wrong. And then there are crimes that are bad because they're morally wrong. And theft is one of them, I mean, and it's a way, it's one of those crimes that can seriously affect, your future. They really can, because I would hire someone with 5 driving suspendeds before I'd hire a thief. You know what I mean?
That's perfectly understandable.
And a lot of employers, I think, feel the same way. So you have a great opportunity now to learn from a really bad mistake you made one time in your life, and not do it again, because the embarrassment of it, the potential consequences of it, it's just not worth it, right?
No, it
And
was,
something that you thought you could probably sell to get a little bit of money has now cost you triple or quadruple what it would have cost you between an attorney and court fines and costs and restitution. Like, this has ended up costing you a lot more money than you ever would have gained from that interaction, from that theft. So, but I think some probation is appropriate. There was a plea agreement under 771. So at the end of that period, it'll be stricken from your record, or your public record at least, so you won't have to, employers won't be able to see it unless you're working for the government, right?
Yes.
But I don't intend to give you very onerous probationary terms because I don't think it's appropriate for you.
Thank you.
But that the plea agreement's the plea agreement, and once you agree to that, these are, what my expectations will be, but I don't get the impression that this is your character, which is unusual when it comes to theft cases, because normally when you have one, you have a bunch.
Yeah,
Well,
I have no intention of making that, so.
does your mom know?
Unfortunately, yes, immediately upon finding out about it, she used it against me to manipulate me.
Okay.
She even
Well-
made a threat that if she had to, she would use CPS against me.
All right,
my
well,
children.
that's not what I was hoping to hear. I was hoping to hear something different about mom, but that's okay.
My mom is not a good role model for
What
anyone.
about your dad?
My father is a typical God-fearing, hardworking man. He works my entire childhood, doing as many hours as he thought.
So you've seen what it looks like. You've had at least someone in your life that's character building.
Yes.
Okay.
Unfortunately, my father lost most of his time to actually show us the proper way.
Well, someone's got to pay the bills. That's the difficulty of being a parent, right?
Yes, it is.
All right. You have a fine of $50, court cost of $50, a state cost of $50, and a victim's rights fee of $75. Those two are mandated by the state of Michigan. You have probation oversight fees of $350 and restitution in the amount of $236.81. You'll be sentenced to 9 months probation. The sentence will be delayed under 771.1. You're to obtain employment and provide proof. And obviously you have to apply, right? So you're gonna apply for 3 jobs a week and provide proof until you obtain employment.
Okay.
You don't have any outstanding bench warrants. You can't drive without a valid license, and you're gonna do a retail fraud prevention course as directed by probation, provide proof and follow therapeutic recommendations. And once you've completed the terms, basically, if you find employment and you complete the retail fraud class, I'm gonna convert your probation to non-reporting.
Rather, he is trying to get disability. If he's successful in doing that.
Well, if he's doing what he's supposed to do and he has documentation that those are his circumstances, then they'll accept that.
I was in fact wondering if for some reason I end up having the same bad luck I've had for the past 2 years with finding employment. What would that become for me?
Are you applying to 3 places a week and going to interviews? Yes, Judge, I will be now because that's your order.
I
right?
have been for the past 2 years.
And you will continue. So that's the answer. I mean, ultimately, the goal is to for you to find employment, but I mean, that's on you. These are the terms, but once you've complied with the course and as long as you're providing proof of, that you're filling out applications weekly, then I'll allow it to be non-reporting. Okay?
Thank you.
Thank you, Your Honor.
All right, we're all set. Thank you.
All right, thank you.
All right. Well, all's well that ends well there for what appears to be a first-time offender in Judge Shackelford's court. Okay. I see Judge Simpson is back from being on the phone with his wife, and I know that everyone here loves a little Judge Simpson. So let's see what's going on with him.
Really, really good.
And maybe if there's time, we'll go back to Louisiana. We'll see.
She could have read it. Court calls the case of fixing housing 401k plan versus Erica Ward.
Good afternoon, Your Honor. Steve Otherly on behalf of Plaintiff Fixing Housing 401k Plan.
Aaron Ward, this one way. Erica Ward on behalf of ourselves. All right. And we have a number of motions.
Yes, we have 3 pending motions, Your Honor. We have landlords, MSD, we have tenants, motion dismiss, and tenants. I've been calling it the omnibus motion because it's actually 3 motions in one.
Okay. And have you, let's start with this notion of the omnibus. I understand what you're saying. Are you guys going to represent yourselves?
Yes, Your Honor.
All right. You know how to respond to a motion.
I would say best I can, yes or no.
All right. I don't know. Did you file?
File a response.
Pardon?
I did file a response.
To the motion for summary.
Your Honor, we received that response.
Pardon?
We received the response.
Yeah, okay, now I see it. It's just, got it. Okay, what motion do we want to start with?
Wherever you'd like, Your Honor.
I really don't have a preference. It might be, I guess, if I take them in order of how they were filed, but I mean, whatever. What was your?
I mean, selfishly, I would like to discuss my motion first. I think it takes away a lot of their arguments.
And let's go there.
Oh, that's fine. I agree.
Go, what?
Oh, I just said I agree.
Okay. Go ahead.
Your Honor, we have landlord's motion for summary disposition. I believe the briefing, like the lease language itself, is clear. The lease expressly provides that tenants must pay monthly base rent of $5,500 without any deduction or set off whatsoever. As this court acknowledged at the November 7th hearing, which we attached the transcript as exhibit E, the court correctly stated this lease language is not conditional. Tenants in their response completely ignore that lease language regarding the rent payment. Your Honor, going to the reply, the response, their sole defense is that this is a residential lease. I believe the argument is meritless. I don't like throwing this word around, but I believe it's also frivolous. Tenants admit in their filings, this court and the circuit court, that they're operating a commercial horse farm on the property Willow Ward Equestrian. Tenants don't reside on the property, and it's a business collecting money from boarders boarding their horses at the farm. I'm going to read paragraph 2 from the circuit court complaint. Erica Ward leases the property to conduct her business, Willow Ward Equestrian LLC, allowed on the property by the lease and Scioto Township regulations as an agricultural/farming use. Erica's business is an equine boarding and training facility. And then it continues. Your Honor, again, at the November 7th hearing, you acknowledged the commercial nature of this lease. It's a 7-year lease term that ends April 30th, 2028. Your Honor, you've read more leases than I have, but I have never seen a 7-year residential lease personally. Paragraphs 4 and 8B also support that it's a commercial lease. I'd also like to highlight in the circuit court, tenants individually are bringing a business interruption.
Can I just stop you for a moment?
Yeah, yes, sir.
Are you really arguing that this is not a commercial lease?
Yes, I'll be arguing that it's a residential lease and the tenant, the landlord the entire time acted in harmony with us in residential lease premises.
Okay, but you guys aren't residing there.
We're not, no.
So what human being is residing there on those premises that could make this a residential lease?
The property is a little bit unique. The property includes an apartment with a furnace. Right, let's say observation. When we received the lease from the plaintiff, I mean, obviously I'm not.
Let me ask you this. Do you know what a residential lease means?
From the residential lease, I believe the onus of repairs are different. There are tax provisions that are different.
Well,
lease.
Customarily, yes. But maybe you need to understand that a residential lease can change, even if, let's say you're successful in the argument, which quite frankly, I'm having a problem seeing that it's a residential lease. Even if it were a residential lease for a period longer than a year, the parties can change the requirement of who has to repair. So basically what that would mean is this: even if it's a residential lease for a longer period than a year, the term that you're complaining about wouldn't matter. The term is where the term is. That term could be in a residential lease, provided the residential lease is for longer than a year.
Sure.
Put another way,
Right.
the obligation to repair can be changed if the lease is longer than a year.
We have to be notified that the obligation to repair in the lease was changed.
Pardon?
Would the plaintiff have to notify us if the obligation to repair was changed?
It wouldn't be changed. It's just,
Because section 6 does state that the landlord should make all necessary repairs and replacements to the property in common areas, including heating, air conditioning, electrical systems.
that's fine. The problem is you can't withhold. I mean, I'll let you make your argument. I just don't think it's going to get you anywhere. But go ahead, counsel.
Your Honor, I'm sorry, did you want me to continue?
Yeah, go ahead.
Your Honor, the parties also signed in addition to the lease, a separate guarantee agreement, which also evidences that this case is commercial in nature. Tenants make a good point in the lease also in our favor that the lease does not contain the normal plate statutorily required notices to a residential tenant. Again, this evidences that this is not residential in nature. Your Honor, even if they're trying to transform a commercial lease into a residential lease and are, impermissibly subletting or allowing someone to live on the property, that alone is grounds for default and termination of the lease. So if that's what they're arguing, that works in our favor because that is a separate ground for termination. Your Honor, the case law is clear that tenants may not withhold rent for repairs in a commercial context. I've cited these cases many times to you. They're cited in the brief and also attached. The unpublished opinion is also attached to the brief. I would continue that tenants are responsible for the actions of their former counsel in withholding rent. I should highlight, just for the record and any subsequent, proceedings, Ms. Tope did file an affidavit attached to the response, Exhibit 4, that it appears to have just copied and pasted large portions of Mr. Ward's affidavit. It talks about how she signed the lease and how she works at Mr. Ward's employer. So I would just like to highlight that for the court. That was in response to our MSD.
Okay, thank you. Before I have you, who represents you guys in the circuit court matter?
Our attorney, Ms. Tope.
You realize that in these two proceedings, whether the representation is made by you or whether it's been made by your attorney, that you can't make inconsistent representations. You realize you can't do that. Huh?
You cannot represent us in our other case?
No, that is not here yet. But maybe I shouldn't use the word representation in this. You can't say one thing in one case.
Correct.
And another thing in another case.
Understood.
So I'm to understand, and while you guys may not have said it yourselves, but have said it through an attorney, as I'm to understand and what I see, your attorney, Ms. Tobe, has made the representation in a circuit court matter that this is a commercial property.
In fact, I'm not going to disagree with you.
Okay.
I don't know.
Now,
Not.
Pardon?
I don't know if she's made that.
But you, okay, folks, this is where,
I
listen, this is where the problem comes in with you not being represented by counsel. Because if you're going to, and I'm going to give you one break, or as many breaks as I think are appropriate, but if you persist in it, there's going to be problems. Because if the representation has been made that it's commercial property there, and then you're left to argue before me that this is a residential lease, that's going to be a problem. A sanctionable problem. Because I almost have to believe that if you're arguing that, you're arguing that in bad faith. I'll put it another way. If you two were attorneys and you came and you know in another action that you're making an inconsistent argument, and I'm not saying inconsistent arguments can't happen, but if in one proceeding you're characterizing something one way, and then in another proceeding characterizing it a different way, if there were a single counsel doing that, I would have very little tolerance for that, and I would be sanctioning. Meaning every time that representation is made to me, you're going to either have to pay the court or you may have to pay attorney fees to the other side.
I understand.
Hold on a second. Do you realize that's where you guys may be headed?
Yes, based on your statements, your judge, I have no reason to not realize that, yes. The only way I can realistically do is talk to Ms. Tope and say, to verify, she's the attorney, we followed her guidance the entire time. But I 100% answer everything.
Folks. She's out of this.
Correct. Yes.
You're now before me arguing this case. I won't be sanctioning her. I will be sanctioning you. Because when it comes out of your mouth, you're stuck.
And your advice is what, Your Honor?
I don't really have advice. Look, folks.
So in this case, Your Honor, my argument, of course, was to comment on the residential aspect of the lease. That's why I was planning.
So
I'm not going to say that.
here's what I'm here's.
Oh, you gotta be kidding. Well, there you go. Judge Simpson took down the feed. Well, there you go. So what was going on there, just to get you up to speed a little bit, and for those of you kind of normally here on TCF, we don't do a lot of landlord tenant, but I didn't know that's what we were getting into at the start. But one person that makes landlord tenant interesting is Judge Simpson. And this is a case where they're arguing over, among other things, whether or not the property in question is residential or commercial. And residential obviously has a lot of different ramifications to being a commercial property. There's different kinds of liabilities, and there's different kinds of expectations for landlords on commercial property versus residential. But the main part of this, the most interesting part, was it sounds like in one instance they were arguing that the property was commercial, the tenants. Another argument, though, somewhere else, they were arguing that it's commercial. It's over here, it's residential. Over here, it's commercial. And Judge Simpson is basically saying you can't do that. If you were an attorney trying to do that, you would get sanctioned. You would have to either pay opposing counsel fees, or you'd have to pay fees to the court. So, very interesting case. Too bad we don't get to see the rest of it, because that's what happens sometimes. Judge Simpson is very quick to pull down these feeds sometimes. So that's what happened there. I'll tell you what, that's a bad way to end the show. I don't want to end the show like that. So what we're going to do is let's triple dip. Let's do it. Come on. Let's head back to Louisiana and see what's going on with the Board of Pardons and Paroles to close out a Tuesday.
In the morning, we're in Baton Rouge at headquarters of the Department of Corrections. My name is Steve Prater. To my right is Jerry Ledoux. To my left is Chuck Tillis. We're going to be hearing your revocation this morning, and state your name and DLC number, please.
My name is Bryson Berg, 754-405.
Okay, and do you have a waiver form in front of you?
Yes, sir.
Okay, did you sign that and you're willing to have this hearing this morning? You're ready to go, right?
Yes, sir.
Okay, good. Well, I'll be conducting the hearing this morning, and you're charged with two conditions. You're charged, or I won't say charged, you're suspected of violating two conditions of your parole. The simple one is the number 10, you owe $441. Is that correct or not?
Yes, sir.
Okay, do you plead guilty to that? You owe that money, right?
Yes, sir.
Okay, all right, well, we'll get that out of the way. Now we'll get to the hard part. In October of 2025, you were arrested for domestic abuse battery. That's a violation of number 4, condition 4, that you agreed to. And the condition was that you'll not be involved in any criminal activity. And you were arrested that day. Could you tell me, are you guilty of that or not guilty?
Not guilty.
Okay, we do have some pictures, and we have a statement. We have a letter from Miss Tori Rivet, or Rivet, however you would say that name. Tell me about that night or that day that this happened, because the pictures do show some problems.
Yes, sir. The day that happened, we had got into a argument because I was literally taking too long to get my hair cut. It wasn't my fault that I was waiting on the barber to get in line to cut my hair. So when I got back in the vehicle, she was real like hysterical with me, and like she was backhanding me, and I tried to like de-escalate the situation as much as I can. So we on the way to the house, and she still hit me in the car. So whenever we get to the stop sign at the subdivision, I grab my bag and I get out of the car. So she parks the car, and she's running behind me, holding my book sack, hitting me. And at the time I had a metal finger guard on my finger because my finger was broken. So I'm walking the opposite way, and she's hitting me, and literally like I threw my arm back in a motion like this, like to get her to stop hitting me. And my metal finger guard accidentally scraped her across her chest. I didn't mean to, and she knows I didn't mean to, but that was just to get her to stop hitting me behind the head. And we left from there because she had broke my phone in the process. So I called my mom to come get me, and she literally said that if I left with my mom and if I left her, that she was gonna call the cops, and said that I put my hands on her.
Okay. Do you have a drug problem?
Yes, sir. Honestly, I have a substance abuse problem, honestly.
And what is your substance abuse problem?
Methamphetamines.
Okay, were you doing any meth that day?
Not currently that day, but I had a problem, yes. I was,
Still
I don't,
You still
So-
got a problem?
no, sir. I feel like this right here really gave me a chance to see where I was going wrong, because I kept a job the whole time. I had a job, I had a good family, but it's like when I would get emotional, or like I would always try to run from reality and go to that, which was the wrong thing to do.
Have you had any treatment, drug treatment?
No, sir.
Okay. All right.
Yeah, like, how long have you and this young lady been together?
We've been, since I came home, but we've been friends for like 7, 8 years.
Okay, so were you living together, or how long have you lived with her?
For about, since I came home, I paroled out to her house.
What are your plans if you're released again?
I want to go to I guess like a inpatient, like a rehabilitation program, like a rehab program, I guess I've been doing a little research that I can, and found out it's like a 28-day program you go into and you go through the steps, and then from there they can get me to a halfway house, like a sober living home, to where they can help me get on my feet somewhere away from where I'm from, to where I can have another chance. I can have help. I can have another chance at life. They help me get a job. They help me have a place to live, to where the weight of the world ain't all on my shoulders, on me. I have someone helping me.
So you don't really want to go back and be with this young lady?
I really do. I mean, I just want to be able to get on my feet, to where I can get us a home. I can do what I can for us, instead of me going back to my mom's house, I love her with my whole heart. I would do anything for her.
Okay. Ms. Jerry?
I don't have any questions.
Okay, Mr. Borg, I think that, there's a preponderance of credible evidence that you violated condition 4 and 10 when you were arrested for domestic violence. I've read the letters. I know she wanted to drop the charges, but she said it did occur. But she wants to drop the charges because she wants you out. You admit you have a drug problem, and my vote today is that we revoke your parole. You're going to be getting out 27 anyway, but we revoke your parole with a recommendation to DOC that you be transferred to a facility that has a substance abuse treatment, and also domestic violence treatment, that you be transferred to that particular. And so, we can recommend. Okay.
I can do it.
No, I think that makes sense. I appreciate the time. Excuse me, we're having a little off conversation here. And so I apologize, but what Ms. Ledoux was telling me that if we don't revoke you, but we, in lieu of revocation, send you to a facility that has domestic violence and a inpatient or a substance abuse program, that we can do that. That might be the smoother way to do that. And so it does sound like that might be. So I appreciate that advice. And so my vote, since I'm the first one to vote, in lieu of revocation, instead of revoking you, in lieu of revocation, you'll be transferred to a facility for inpatient or in-house substance abuse training and also domestic violence training because of what occurred in October. So anyway, that's my vote.
I would vote as well. I concur. I would like to see you also have a mental health evaluation. I know you indicated that you had an evaluation in the past, an assessment. I think combination of getting that particular aspect handled, getting you some substance abuse treatment, and understanding the domestic violence component. So that's my vote as well.
Mr. Tillis?
I concur with my colleagues.
Okay, well, that's our decision, Dave. Do you have any questions? I know it's kind of complicated, the in lieu of revocation. You're going to be transferred to a facility, a DLC facility that has these treatment programs. So you don't have to worry about doing your research. We did it for you. So you got a good deal. And I know you're in, I believe, let's see, you're in Lafourche Parish, and I didn't have you introduce yourself. The staff at Lafourche, would you please introduce yourself for purposes? Okay.
Deputy Jennifer Exnicious.
Okay, thank you for hosting us today and putting this together. And, so as of 11:07 this morning, in lieu of revocation, you'll be sent to a facility that has the training program that we mentioned.
Yes,
Right?
sir. Is there, like, how long will the treatment be?
No, sir, we'll work that out with somebody else. We don't deal with that. We just kind of shuffle the players, and how long it takes to do that is up to the DOC, the professionals. End of the hearing.
Well, it wasn't denied. It wasn't approved. I guess it's just transferred to a DOC program. I don't know. It's not really a smooth. I don't think that would make for a great stinger, but that's probably what's going to happen there. All right, friends. Well, on that note, it is about that time, isn't it? About time that we wrap it up for the day, call it a day here. Michael Groff, I've been filling in for the great one, the man, the myth, the legend, Mr. Dan Soul. He'll be back tomorrow, and actually, he'll be back tonight, 8 p.m. East, 5 p.m. Pacific for a sidebar, as will I, as will Ashley, Austin. I believe Lindsay is joining us as well. So we're going to have our full panel back. It'll be our first show of the brand new year. And we are really looking forward to that. Topic for tonight, new laws that are coming on the books. Yes, as if we don't have enough of them already. We'll have some brand new laws coming in for the new year across the country. Some of them silly, some of them serious, some of them weird, whatever. I know Dan, who is normally the host here. He is a big proponent of we should eliminate like half the laws that are on the books, maybe even more than that. And can't say that I disagree with him on that one. Too many laws. But anyway, if we didn't have laws, I guess we wouldn't have court, and that means we wouldn't have TCF, and we wouldn't. I wouldn't be able to hang out with you guys. It's been quite an interesting morning. We've had lots of fun and frivolity. We had somebody from an AI slop channel come in here and say hello to us. An AI slop imitator channel that calls themselves Courtroom Files. No, this is the Courtroom Files. Also on that note, courtroomfiles.com for all your Courtroom Files merch. And Dan will be back with you tomorrow morning, 10 a.m. Eastern Time, 7 a.m. Pacific. And I want to mention one other thing here before I get out the door. First of all, thank you guys so much for your super chats and all that. Really, really do appreciate that. Those do go to me as the guest host here, and I couldn't thank you enough. But beyond that, starting next week, brand new time slot here. The show will start at 9 a.m. East, 6 a.m. Pacific, 30 minutes earlier for channel members for the pre-show. So you'll want to check that out. Dan will be hosting that, and God willing, should I fill in? Of course, that means I'll be up extra early as well. So we all will, because we'll be all of us will be tuned in. So Again, thank you to everybody. Really do appreciate it. We'll be back here for Sidebar tonight and then back here for the live show tomorrow morning. Thank you so much once again. Goodbye, everybody.